Hello, my friends. And thank you so much for coming to spend part of your, I have to look in the corner to see what the day is, Tuesday, November 7th with me. Is everybody all Maya'd out today? It's a very long day for those of us that have been following this trial. The closings finally happened today. And I put a poll in the chat because I know that there are so many people who were following this today. Other channels that were doing shows on this today after the live stream ended. I know a lot of you watch it with Recovery Addict, and that's great. And I watched him too, and I heard him shout me out a couple of times today. And I saw a couple of you shout me out in the chat over there today. So thank you for that. You guys are awesome. So it looks like from the results of my poll so far, at least 56% of you watched the live feed and at least one other creator. When I say live feed, I'm including Recovery Addict in live feed because that is where most of you choose to watch it, because he does have a very kind chat over there. And I know that so many of my viewers are afflicted, unfortunately, with CRPS and other chronic pain disorders. So we consider ourselves to be a safe place to watch the stream too, or talk about the case, or come in the chat, because we have a lot of friendly people here. And my moderators are amazing, really. They're the best on YouTube, and they don't let the bullies in here. So I know you guys like it here and you feel safe. So I'm glad. That's what we're trying to do here. It's the least we can do, right? I've received so many really nice emails from you guys and messages, and I thank you for that. And you've told me your stories, and I hear you and I see you. And I know Villa Ray called in last night, and she was in the courtroom with her family, and she has followed up with me a couple of times since then. And she told you that her son also is afflicted with CRPS, and he's 21. So shout out to him. I don't know if he's watching. But apparently the genetic component of this disease is real. So that's what she wanted you all to know. Pass that along to you guys. There's only about 18% of you that did not watch anything today, but I'm assuming that if you're here with me, you are familiar with the case. And so I didn't really know where we should go with this, because so many other people have covered it already today. And I know you guys were so into it and you're probably watching. So I don't want to regurgitate everything you've already watched. I don't think that would be very fun for anyone. But what I think I was going to do first, I like to work backwards, as you know. So what I was thinking of doing is going over the note that the jury sent out at 6 o'clock. At 6 o'clock, the jury sent out a note saying, we will be done at 6:15. So everybody was freaking out, like, oh my God, they have a verdict. They're coming back at 6:15. We're done at 6:15. And I'm thinking, no way. There's no way. There's no way. They mean they're done for the day. They want to go home. Because the judge had said, let me know what time you want to deliberate until. But then they sent another note. And this second note caused a bit of confusion and a bit of flurry and a bit of an issue. So why don't we talk about, well, we can talk about the sanctions motion, but there's nothing that's going to be decided now. I think we covered that pretty much last night. Did they talk about the sanctions motion in court today? Because admittedly, I could not sit in front of the TV or listening to the YouTube all day long. But my understanding about the sanctions motion was that he was going to reserve decision until after the trial's over with regard to any penalties that he was going to be laying on the defense firm. So yeah, no. Okay. So he hasn't said anything about it. So I think he's going to just push it off, take it under advisement, as they say, talk about it later. So yeah, there was no talk. Yeah, I don't think he's going to talk about it until later, till after the trial's over. I mean, let's not muddy the waters, confuse the issues, whether he decides the defense firm did what they did intentionally by withholding evidence, by being less than honest, whether there were any ethics violations. I think that's going to be something that's going to be kicked down the road a bit, so as to not pull focus from what the real issue is here, and that is getting to a verdict. And that's what we want. And I don't think it's going to be quick. I mean, these are calculations, and you're going to see from the note the jury sent out that they have to do calculations. It's math. But based on the note that they sent out, it makes me think, okay, they're finding for the plaintiff now. They're just trying to figure out how much. But based on the verdict sheet, which I think we should also go through, and then we'll look at a little bit of the closings, because some of them were very poignant. Some of them, I think, were not, and we're a little insensitive, and you can let me know what triggered you today. But let's start. Why don't we start there? So we're going to start with, I think that's where I queued this up to, because I have a couple of videos queued up here. Let's go to the end of the day when the judge was reading this note. Yeah, they did seem a little silly, the jury, right? They do. They seem super comfy. And I'm going to tell you, if the foreman or forewoman is the one who's in charge of sending out the notes, I do not think it was juror number 1, and I'm going to tell you why. Juror number 1 was the one they wanted removed, and because they thought he was plaintiff oriented, former law enforcement or retired law enforcement or current law enforcement, but they wanted him off. Judge said no. First, we thought that Anderson was going to consent, and then he checked with Jack. And I think you guys were right, because when I went back and read the chat last night or this morning or the comments, I think that Jack saw the jazz hands from a woman in row number 2 sitting over at the defense table. And I think he saw that. And I think that's when he called Greg over, and he's like, no way, no way. They want that, so I don't want that. So I think that was a great point that you guys wrote. Yeah. Yeah, and I wonder if first of all, I wonder if they watch any of the YouTube coverage on their own trial, or if anybody in their office watches it. And secondly, I wonder if she was admonished for that. I don't know if she's an attorney. I don't know if she's, paralegal. I don't know what her position is and why she's sitting over at the defense table. But you did notice a couple of doctors in court yesterday, 4 or 5 from the hospital. So they looked like quite the united front. I saw Dr. Malik and a couple of other doctors there. I agree. Yeah, that was just, it looked like she couldn't even control it. Like, we got to go rewind that and watch it a couple of times. And it was bizarre. It was a weird reaction. And it was, that's going to be a meme in addition to the other meme that, who sent that to me? Amy in Boston sent me a screenshot of Hunter when we were trying to caption the meme last night. We had a lot of great captions on that. So I know a couple of other people are live right now. So this is going to be a very intimate stream. So let's enjoy ourselves, shall we? Let's watch Judge Carroll. Oh, somebody else pointed out to me, and I did not know this. Was it Magical Mary? I'm going to have to go back to the comments from yesterday. That when Judge Carroll was 16 years old, he was with his mother. His parents were getting divorced, and he was with his mother in court. And the judge was, I don't know, I can't remember his name. Who's the appeals judge for the defense? Begins with an A. That was the judge, right? Mary, if you're here, tell me again the story. I could go back and look for the comment, but I can't. Oh, wait, do you pronounce your name Melaine or Melanie? Because I hate when people call me Melaine. I'm like, it's Melanie. So if your name is Melanie, I don't want to mispronounce your name. Altenburn, right? Altenburn, right? Okay. So when Judge Carroll was 16 years old, the judge in his mother's divorce case was Altenburn. Yes. So they have deep ties. It's a very, very small pond. Once you get into these ponds, they're very, very small. Even here in New York, Suffolk County is a very, very small pond. It's a very, very small corrupt pond for a while. And I'm sure that some of you in the chat can agree with me on that. All right, let's listen to the note that the jurors sent out first, and then we're going to work our way backwards. And then I thought we may go back and watch the Economist's testimony, because it's been a while since she testified. Hold on a second. All right, let me know that you can hear this. And this is the note that came in from the jury around, I'm going to say around 6:15.
Answer the questions in the order they appear.
Okay, except that's that's not what I was going to do. First, I was going to look at the verdict sheet. So let's go to the note first, because everyone's already talking about the note. So let's go to that, because a lot of the streams that were covering this earlier today, did not see this part. So let me go to that first. That was in the 10th hour of the stream today. Verdict watch. This is verdict watch is insane. 3:15. It was amazing that they were all right there. I I thought no way in hell would they have a verdict today. I can't believe they all stuck around. I guess they just wanted to stick around so that they could watch the jury be dismissed. They'd be there for that.
Well, got another note from the jury. Says, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. Here's the verdict form.
Okay, did everybody catch that? There was a y'all in there and an ain't in there, and that is not the way that juror number 1, the allegedly biased juror towards the plaintiff, had phrased any of his questions. And I'm wondering if any of you recall any of the jurors asking questions using y'all or ain't in the phrasing. Okay, so it's Melaine. Hello, Melaine. People call me Melaine, they call you Melanie, so that's crazy. Exactly, Miku. That's what I thought too. Way too much math for a verdict, even in one day. I mean, how do you even come up with numbers? Yeah, did you see the judge's face when he was reading back the note? You know what? Let's take it back. Let's go back to 1 and just watch that one more time, because we like to do that here.
We have not another. Well, got another note from the jury. Says, y'all, we have not been able to locate any of the calculations about future amounts. Witness Kirby was on Zoom and Whitney mentioned them today, and it was said that we'd have all this at deliberation. Well, if we do have it, we ain't found it in all these files. So without these witness figures, you'll be lucky if there's enough awarded to pay your gas to drive to court, or we'll be here till next Friday. Here's the verdict.
You know, you can interpret that in 2 different ways. Without that, without the future expenses, you're not going to have enough gas money. So are they not intending on awarding any past pain and suffering? Is this all going to be future pain and suffering and future loss of income, future damages? Are they not going to award anything for past? Because they're asking for past too. So I thought that was a little interesting. And then the attorneys get up and they start talking about how they're going to cure this, and they have a couple of ideas. And the idea that they finally settled on was they were going to see if they can get a rush transcript of the Economist's testimony and read it to the jury tomorrow. And then they're arguing about who's going to read it. It's going to was it an error for Anderson to not enter that report into evidence? Did he try to? Did he forget to? I don't know. Let's watch a little bit of what the attorneys had to say about this, because hopefully this is not going to turn into a huge problem. And hopefully the jury's not going to be pissed off that they're going to have to come back now and listen to this testimony again, because they were told that they were going to have this with them in the jury room. And apparently they looked through the hundreds of pieces of paper that they had and it wasn't there. So I think they were just trying to be funny. I don't think they were really annoyed by it. But I think definitely they're finding for the plaintiff. It's just about calculations at this point.
The note form, if y'all want to come up and examine it.
It does speak very slowly, so even on high speed, it's normal speed.
Okay. What about can we get the transcription of Ms. Kirby overnight and then read her testimony?
Well, I mean, you all have hired a private court reporter, and if you wish to pay for a court reporter to do something, that's between you and the court reporter. That being said, what is actually in evidence on this issue?
So, testimony, I believe, and we moved, and I think we marked for identification, but I don't know that we moved in or could move in her report. I tried to get her report in. Usually the Economist comes in, but I don't think I was allowed for that to go in.
So the report's not in evidence?
I don't think so.
Yes.
We did move it.
Well, it is what it is at this point. So what are we saying?
Well, I think the thing to do is let them know that we'll try to get her testimony transcribed overnight and then bring it in tomorrow morning. Hopefully our court reporter can give us an official transcript to be able to read to them, and that'll give them the numbers. Unless somebody wants to agree to let them see the report, which is marked for ID, I try to get it in.
Well, what is the defense's position on what to do?
There could be a readback, Your Honor, of the testimony. I'm exceedingly, I haven't looked at that report lately. I'm exceedingly reluctant to agree to have a forensically created report put in evidence. There are several bases upon which we objected to it and upon which the court excluded it. And I'm reluctant to revisit that. I'm frankly kind of surprised with this jury, with the note taking that went on at the tenor of the note, because I would have thought that they jotted most of this down.
I'm kind of surprised too, to be honest. So apparently he tried to move it into evidence. It was objected to. The judge did not let the report into evidence, which, that's a fair ruling. Usually an Economist report would not be something that the jury would get to see. They would have to listen to the testimony and take notes. So I think somebody said they took like 60 notepads worth of notes. So there's a lot of notes. Somebody said how many days this has been going on. I think, are we on day 31 today or day 32? I'm not sure, but it's been 9 weeks. It's been 9 weeks.
But I'm very reluctant, I suppose, to say anything other than the jury has heard the evidence and is expected to recall that evidence and trust its collective wisdom, or to read back the testimony.
I'm surprised that he'd even agree to read back the testimony at this point. At this point, he's like, okay, they can't figure it out. Forget it. Then maybe they could just award 0, but we'll see.
The jury didn't actually ask for a readback.
We offer that as an option nonetheless to resolve their apparent dilemma.
I'm sorry.
Mr. Anderson is asking if we should offer a readback as a.
That's what I was suggesting.
Okay. So perhaps then, since both sides are okay with me offering a readback, is to tell them all the evidence you have all the exhibits that are in evidence. And if as it relates to witness Kirby, we can ask the court reporter to see if the court reporter is able to type up the testimony. Now, are we going to identify what part of the testimony, or is the entire testimony going to be read? If they ask for it.
I do not believe was longer than 30 minutes max. I believe we were in and out on that. Mr. Whitney has a different memory. I recall that being exceedingly brief testimony, and I don't think there was much cross at all on it. So I think that if there's an agreement to read it in just as to that specific, fine. If not, reading the whole thing is not going to take that much time.
It was an hour and 15 minutes. I wrote it down.
This is not like, 2 hours of testimony. This was a pretty basic. She was on Zoom. I wish she had recorded. We could play it back for her.
Was it recorded?
I don't know. I don't know if you can record Zoom on the court proceeding.
We don't do that.
Okay.
Didn't think.
Okay, so that's interesting. They do not record the Zoom feed, but Law and Crime has it. I guess they don't want to use Law and Crime's footage. Yeah, Havey, there was more than one note. The first note just said we will be done at 6:15, and then that was the second note. So everybody was kind of wondering on all the live feeds, like, oh, they have a verdict. They have a verdict at 6 already. And I thought, no way. No way. There's no way that they could have gotten through the entire verdict sheet in that amount of time. So now they're going to need to come back tomorrow, listen to the testimony of Kirby, who was the economist that testified as the plaintiff's expert witness, who testified about all the future costs. And then they're going to go back and have to go start their calculations. But here's the thing. Based on the verdict sheet, it looks like they didn't even get past the first question. So eventually...
Judge, if we're going to read it back, I think we read the whole thing back. And my recollection is similar to Mr. Anderson's. I don't recall this being more than 30 to 40 minutes.
Well, my recollection of the case law on readback is as follows, that if the jury's asking for it, then obviously we can do it. And certainly that's not a problem. Obviously, are we opening the door for them to start asking for readbacks on everything, which of course it takes a lot of time. And
yeah, that's the risk, right? Give them an inch, they want a mile. But hopefully this is all they need to just start calculating, and then they're not going to need to listen to anything again. It seems like they've already made up their mind. It's just a matter of how much. But I'm hoping it doesn't mean they're only awarding future damages. Hope I'm reading that wrong.
I can tell them I don't know if we're going to be able to get it for you overnight or not, but I'll say it's going to take some indeterminate amount of time to get it back. But unless the jury's request is specific, I don't want to do anything other than read the entirety of the testimony, unless the parties jointly agree to some narrower scope. And maybe if you do get the testimony tonight, you can discuss amongst yourselves what to.
It's certainly reasonable. And once we get it, I think we would then correspond with the defense.
Like they're going to agree on anything. I mean, we've seen how that works out so far. All right, let's go to the verdict sheet for a minute, because I want you guys to get a good look. And I'm not going to let him read it to us. We're going to look at it page by page, and I'm going to just explain it to you. I don't think we need to listen to the judge reading it, but it gives you an idea of exactly what they have to talk about. And there's a lot to talk about. And it's not just a matter of, do you think he's guilty or not guilty? Raise your hand if you think he's guilty. Everyone raises their hand and then they're out of there. It's not like that. There's a lot of questions. There's a lot of things to discuss. And that started in hour 5. Let him talk just a second here. And like I've been saying all along, the jury has to be unanimous. There was so much chatter in the chat about, no, it has to be only 5 out of 6. No, in Florida, it has to be unanimous. And he will reiterate this here.
Performance is up. Okay. We, the jury, return the following verdict. So ask you to go to the next page. 1, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 7th and October 13th, 2016?
So the false imprisonment claim is only between October 7th and October 13th. October 13th was the day that the judge in the dependency court decided that he was going to place her into state custody.
You will answer either yes or no. And the form will tell you what to do next. For instance, if your answer to question 1 is yes, please answer question 2. If your answer to question 1 is no, your verdict is for Johns Hopkins All Children's Hospital on this subclaim. And then you will skip questions 2 through 5 and go to and answer question 6. Question 2, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment?
Right there. Expenses in the future based on the false imprisonment. They didn't even get past that question. And it's pages long. Anybody know how many pages long the verdict sheet is? It's a lot of pages. I think it's like 16 questions. So really, I think that's where they got to. And they're like, how do we even figure this out? And then they're looking through all of their papers, trying to figure out where these calculations are, or if there was some chart, that Anderson may have given them from the Economist. They're looking for the report. They can't find it. And that's really as far as they got with this. But let's just, when they start putting the pages up on the screen, then we can look at them ourselves.
Occurring between October 7 and October 13, 2016. You put your answer there on that line. Please answer question 3. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for enjoyment of life sustained in the past? And then this is where I had to handwrite in, and to be sustained in the future. So you don't see it on your screen right now because I have just added, but it is on the verdict form. I have handwritten it in this blue ink. Okay, so I'll read the whole question again. Number 3, what is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October 7 and 13, 2016? The form tells you to answer question 4. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessarily or reasonably obtained by Jack Kowalski for his child, Maya Kowalski, in the past, or to be so obtained in the future until Maya Kowalski reaches the age of 18, based on the false imprisonment occurring between October 7 and October 13, 2016? Please answer question 5.
Okay, so they're still on the first cause of action, which is false imprisonment, and they're asking for past medical expenses and future medical expenses. So they didn't get very far at all, you guys. This is going to go on for days, I tell you. This is going to go on for days, in my opinion. Somebody asked, is this, what did you say, Scott? Did I highlight it? Is this the typical amount of questions? It depends on how many causes of action are left standing. Remember, this was the 8th amended complaint. I think it was something like 90 pages long. A lot of the causes of action were either dismissed on summary judgment motions, directed verdicts for the defendant. There's only, I think, 7 causes of action remaining. So they have to have separate questions for each cause of action. So the first one is for false imprisonment. They're going to first determine whether or not they think there was false imprisonment of Maya between those dates. And if they do think there is a false imprisonment, then they move on to damages calculation. So for each of the 7 causes of action still remaining, there's questions. So yeah, it could be, depending on how complex the case is. We have wrongful death in here. We have medical malpractice and battery. So let's move on and see what else they need to decide, because it's going to give you an idea of how long this is going to take. This is not going to be quick.
Under the circumstances of this case, state whether you find by clear and convincing evidence that punitive damages are warranted for the false imprisonment occurring between October 7 and October 13, 2016. You will either answer yes or no. Please go to question 6. Now, question 6 is the second subclaim for false imprisonment. Number 6, did Johns Hopkins All Children's Hospital falsely imprison Maya Kowalski without legal authority under circumstances that were unreasonable and unwarranted between October 18th and October 20th, 2016? You will answer yes or no. And again, the verdict form tells you what.
Okay, so those are the 48 hours that she was being videotaped in that EEG room. It's a separate cause of action, whether she was falsely imprisoned for the week before the juvenile court sheltered her at the hospital, and then again for that 48 hours.
To do. If you answer 6 yes, you will go to question 7. If your answer to 6 is no, your verdict is for Johns Hopkins All Children's Hospital on that subclaim. You will skip questions 7 through 10, and you will go and answer question 11. Number 7, what is the total amount of Maya Kowalski's damages for medical and psychological expenses to be incurred in the future after she reaches the age of 18 based on the false imprisonment occurring between October 18 and October 20th, 2016? You will note I put a instruction. In awarding damages, please do not duplicate any damages you awarded in question 2. There's a line for your response, and the form tells you to answer question 8. What is the total amount of Maya Kowalski's damages for pain and suffering, mental anguish, inconvenience, and loss of capacity for the enjoyment of life sustained in the past and to be sustained in the future based on the false imprisonment occurring between October.
I mean, that's interesting that it's all in one question. Usually it's separated out. How much do you award for past pain and suffering? And then how much do you award for future pain and suffering? It's a little bit of a mishigosh, I gotta say. But hopefully they can figure it out. But again, it's got to be unanimous. So they may agree on the liability and they may say, yes, she was falsely imprisoned, but then they may fight about how much money to award. So, they have to be unanimous on everything. That's why I think it's going to take a long time.
18th and 20th, 2016. There's a space for your answer. Please answer question 9. 9. What is the reasonable value?
Okay. And then we go to question 9, and I can enlarge this and we can just read it ourselves. If we can read it. It's pretty hard to read. What is the reasonable value or expense of hospitalization and medical, psychological, and nursing care and treatment necessary or reasonably obtained by Jack Kowalski for his child in the past or in the future until she reaches 18 based on the false imprisonment for those 48 hours? And then under the circumstances of this case, do you think that punitive damages are warranted for the false imprisonment for those 48 hours? And it has to be a clear and convincing evidence standard. And remember, somebody said these are 68 pages. No, those are the jury instructions. And that's where the law is. The law will tell them what a clear and convincing standard is. We didn't go through all of that because it's very long. But that's what those 68 pages are. I think this may be something like 8 pages. Right. Then this second cause of action is for the false imprisonment on January 6th of 2017. And I believe, correct me if I'm wrong, that's the date when the photos were taken. That's the date that she went to court. Yeah. And then they're looking for whether it was unreasonable and unwarranted, whether that constitute false imprisonment, and then what are the total amount of medical and psychological expenses. She's testified that she has PTSD because of that event. So you see this goes on for each claim. That medical expenses past and future, and then whether punitive damages are warranted. So we've got 2 claims of false imprisonment. Then we have the battery claim against Catherine Beatty. Did Catherine Beatty and any bedside nurse commit a battery on Maya Kowalski? That's for the same thing, for taking those photos on January 6th of 2017. And in the jury instructions, it will tell them what a battery is under the law. It's an unwanted touching. And again, what is the total amount of Ms. Kowalski's damages for psychological treatment in the future? This is only in the future. And pain and suffering. So you have medical expenses, and then you have pain and suffering from
Catherine
just
Beatty
that event.
and any
And whether punitive damages are warranted in that battery cause of action. And then there's a separate cause of action for the battery, including Kathy Beatty hugging, patting, kissing, and placing Maya on her lap. And if they say yes to that, then they move on to past medical expenses, future medical expenses, pain and suffering. And let's see if there's no punitive damages on that cause of action. And there's a medical malpractice cause of action on behalf of Maya, whether Sally Smith was an apparent agent of Johns Hopkins, and whether okay, this is interesting. Was Dr. Sally Smith an apparent agent of Johns Hopkins All Children's Hospital at the time and place of any treatment she provided to Maya Kowalski? Well, I would argue that they would have to first agree on whether or not she provided any treatment to Maya, but they didn't ask me to write the verdict form. So you see how we have to go through each cause of action. This is going to take days, you guys. It's going to take days. And this is the standard for medical malpractice. It has to be a certain under the law. So there's a lot of things, loss of earnings, past and future. And then they get into the wrongful death of Beata. So there's a lot of things that they have to settle on here. I do not think this is going to be quick. So you can probably go about your life for the next couple of days, because I think there's no court on Friday, right? I don't think there's any court on Friday. So today's Tuesday. And really, it was a holiday. I think, I don't even know that courts usually open on election day. Is it? Tuesday, Wednesday, Thursday. So we'll see. We'll see if they come in before the end of the week. I don't know. I don't know if you guys are betting on this anywhere else, but I'm not too sure. Yeah, there's no court on Friday. They're ready to do the calculations, but they're going to have to listen to the readback of this testimony. All right, so why don't we watch a little bit of a portion of Anderson's closing, and then I want to watch a little portion of Shapiro's, and I want to know how you felt about that. And then we can watch some of Anderson's rebuttal, and I want to watch Whitney do the calculations, because I want to know what you think about the calculations and whether you think that the amount of money that they're asking for is appropriate or whether it's going to shock the jury. And then I'll tell you what I think. All right. So let's see. We can let's go to this part of Anderson's closing. You have tissues? Did you guys cry when you watched this earlier today? I want to listen to what he says about the wrongful death of Beata, because I thought that this was going to be the hardest verdict for them to come to, was whether or not the hospital was responsible for Beata taking her own life. And it's not a cause of action you see very often. It's not permitted in a lot of states. I don't think that would fly in New York, because you couldn't show a duty to Beata from the it's a very, very iffy cause of action, but I think he laid it out pretty well. So let's see what he's got to say about that. Okay, deep breaths, everyone, deep breaths.
And there must have been some words, because she was challenging them. Understand about how this disease is? I've been coming here for forever. Why don't you people pick up on this? And that ticked them off, because she was challenging them. And there must have been some words back and forth, because somehow, somewhere, they decided to completely change over the diagnoses. And whether they did it immediately in the record, or whether they simply did it in every way they approached everything, and everybody that they told outside of the hospital, there's no question that they tried to change the narrative here. And walking in as a normal family with a child with a debilitating disease, they walked out suddenly with Beata as the enemy and Maya as a liar. That Maya was making all of this up, and that Beata was somehow encouraging it. So whatever happened, and I'm pretty sure it was that Beata started to ask people's names, and she started to take down those names, and she started to ask very, very pointed questions. Because remember, within the first 24 hours they were there, they called risk management. Within 24 hours, with the patient they'd had for a year and a half, they called risk management.
I think he's right. I think she probably did start taking names. I don't know if that there's any evidence of that, but I think he's 100% on the money, and that's why they were threatened.
Something else very interesting here. Remember one of my first witnesses, Debbie Hanna? She was the social worker that was brought in, and it wasn't her regular gig, but she was brought in to help on this. And she sat down with the Kowalskis, and she said that they were like every other family with a child that was in a lot of pain and with a desperate disease. They were incredibly concerned, but she didn't see any signs whatsoever of abnormal behavior. And this is a social worker. This is the one that's supposed to pick up on stuff like this. And there's another thing I want you to keep in the back of your mind. She was never allowed and never did finish her psychosocial evaluation, which is what you put together to see whether there are any psychosocial problems. Are there any psychiatric issues going on here? Is there something going on that maybe we didn't spot over the past 15 months and 50 doctors? She was not allowed to complete that. And risk management took over. It's very strange. Very strange. After that, what did we see? We saw Sally Smith brought in. What the heck was Sally Smith doing there? Why were they bringing her in? Why did they have her checking records on October 8th, the next day, without the Kowalski's authority, by the way, and without their consent and without their knowledge? Why was she going in there and looking back at all these records? What was her role here? Sally Smith eventually comes in to see them, and she doesn't identify herself as Sally Smith. Whatever she's trying to say up there, you know she came in a lab coat, and she came in with her doctor's pass. You know she walked in, and she started to try to get information from them without identifying herself. She was trying to set up a case or some complaint or something. She was the hammer. She was the hammer that they might need down the road.
Do you remember what Dr. Cave said on our live about medical gaslighting? He said, when you're a hammer, everything looks like a nail. That was interesting. And Anderson just used that analogy. She was their hammer. Wonder if he saw Dr. Cave's interview and he took it.
Should the Kowalskis come back, make any complaints? Remember, this was a place where if a person complained, there was retribution. Dr. Corcoran, if a person complained, then there was a chance they could lose their jobs. Nobody was complaining up and down, and no one wanted to hear any complaints about them. And here was Beata taking down names. They panicked, and they decided they weren't going to let this brusque lady with an Eastern European accent coming in and telling them how to do their job and what they could do and not do and what tests they could do and not do, right? They got really, really upset at being bossed around by this lady. And she was a nurse too, which made it even worse. By the way, why are they so worked up about Beata Kowalski, an infusion nurse, giving her child infusions? I never made the connection there as to what that's supposed to signify to anyone. So after that, you can see here, well, beforehand, you can see the times leading up to it. After this, there's a psychological evaluation on January 6, 2017 by Dr. Duncan. You got that back there. There's no problem found. They bring in Dr. Lewis, who was working for the state. He was not one of their doctors. He was working for the state. You got to look beyond what you're being told to see what was really going on here. Dr. Lewis, whatever Maya's saying, he's putting down what he wants to say to try to support a narrative. But even he.
Is this like the yearbook photo of every person you ever hated in high school? I mean, like I hate to laugh, but sometimes we have to make a joke every now and then so that we can catch our breath from all the crying that we're doing. But yeah, this looks like a photo montage of every person you hated in high school, where I used to scratch out the picture in the yearbook of the people you didn't like.
He can't bring himself to say that this is psychosomatic. He says you got to get a pediatric neurologist to look at this to confirm whether or not there's a physiological basis, right? So Sally Smith is in here, and all of a sudden Sally Smith starts running the show. She was an apparent agent. Under the definition that you're going to get, I want you to check yes on apparent agent if you agree that we've proven through the testimony of Elena Kushner, who also, amazingly enough, had an Eastern European accent, and also had the same experience of Sally Smith coming in a white lab coat, and starting to ask questions. No introduction. No, hi, I'm Dr. Smith. I'm here to help you. What can I do? Anything like that. No, probing questions to try to see what could be uncovered. The Kowalskis became the enemies. The Kowalskis had become the enemies, right? And remember, this was a hospital that was under immediate jeopardy of losing its license, right? These people were worked up, and they didn't want anybody rocking the boat. But in any event, they talk the Kowalskis into staying. They tell them, we're going to help here, we're going to help there. And Beata says, no, we're going to go back, like we did on the first, to Dr. Hannah, and we're going to complete the ketamine infusions because you guys can't help us. No doubt Beata brought her in to see if there could be an intubation and greater amounts of ketamine to try to get her out of this crisis. And when they couldn't do it, she concluded, why are we here? And tried to leave. And she was told, well, if you leave, then you're AMA and we're going to call security. And that's in the records. So they were forced to stay. And as much as they try to dig around in the records, ask yourself, do you believe they really wanted to stay in that hospital when there was no reason to do so? Maya was not getting the care she wanted and the care that the parents wanted. You know, there's a lot of people watching this. There's a lot of people looking at this. There are CRPS patients. There are parents who have children in crisis trying to figure out what to do. There's a lot of people who are paying attention.
Maybe you're right. Maybe he is watching YouTube because everyone else is watching this on YouTube. He's right. And that's why they haven't settled, because they want everyone to know about this. And they want everyone to know about CRPS. And they want everyone to know that if you take your child to the hospital, your parental rights can be stripped within a very short period of time. If somebody like Sally Smith in a privatized DCF system disagrees with the medical treatment that you are choosing for your child that has been prescribed by a doctor, that is a really freaking scary proposition, guys. And it's real. It's real. And knowing that this case was going to be televised too, because if this case was in New York, we wouldn't be watching it. There are no cameras in New York in the courtrooms. That's why SBF's trial wasn't televised. That's why you didn't see Ghislaine Maxwell. That's why so many, that Nexium trial, none of these trials are televised in New York. So this is huge for the CRPS community. And I know there's a lot of you in here. So you're all warriors. Flyer B. I don't think it hurt Maya's case that she left the courtroom during the closing arguments. I didn't know that she did, but if she did, I don't think it hurt her at all. No, it just, I think it shows the jury that she just can't. I mean, she can't. How much longer can she sit there? This is really, really hard for her. And you're going to see, she's going to start crying soon.
What you're doing here. And in this instance,
Objection is sustained.
Thank you.
and it's important here to consider what was going on behind the scenes. So through the course of the time from October 7th up until the 13th, when this order was obtained, they desperately wanted to get out of that place, but were not allowed out of this place, although they tried to talk them into. Johns Hopkins did their best to try to convince the Kowalskis that, well, she's got withdrawal symptoms. She'll have withdrawal symptoms. We need to wean her down. Everything you've been doing is wrong. And you know what? The Kowalskis were at least listening to them. They didn't buy it, but they were at least listening to them. They weren't uncooperative about this, but all they wanted to do was get out of there and get someplace where Maya could be properly treated. That's the reason they came in. They had no reason to stay there. They didn't want Maya under this hospital's care if the hospital couldn't do anything more for them. That's called false imprisonment. And that's where you would check yes on that particular one.
Yeah, I don't think that's a hard one to check yes on. Tell me what you think. Look how the court reporter is wearing pink. Think that's a sign? Think that's a I support Maya pink sweater that she's got on there? If it is, it's awesome.
I'm skipping around here, but in your verdict form, it's interesting. You've got different events listed, okay? And you're going to be asked individual questions about individual events. And so this is one of them. Another one is when when Kathy Beatty and company pinned her down on January 6th. That's another one. Right. He's right. I need to talk about the suicide.
Yeah, all right, here we go.
I'm interested here in the circumstances living up to Beata. You know, her motto was live with passion, right? And she had everything in the world to live with, live for. And she died with the same passion. Consider the fact that she came from a communist country and saw her father dragged out of the house by the powers that be, right? Beata Kowalski gave her life for her child because she knew Beata was prescient. She knew something was going on in that hospital, and she had been told repeatedly about how her daughter was suffering. And she knew enough to just listen to her daughter. And you heard the phone calls to know what was going on. And every time somebody saw her daughter, any of the neighbors that got in, any of the priest, anyone else who got in, she was pumping them for information. She knew exactly what was going on here. And so as Maya started to get worse and worse and worse, the anxiety of Beata went up and up and up until it came about finally that Beata determined, unless something drastic was done, there's a pretty good chance her daughter was going to die in this hospital. Why? She'd already seen a friend's daughter die from CRPS. CRPS can kill you. And in this instance, where you've got someone who is becoming so weak that they're laying down and they can't even hold themselves up, you're subject to blood clots that can go to the heart and kill. And that's what Beata was concerned about. There was retaliation against me because they knew I was going after the ICU. Filing charges with me with DCF automatically makes them automatically immune. But what it says here is that Beata knew what was going on with her daughter and knew she had to do something drastic. She knew they were retaliating against her. That she knew that she was the key. If she was in the picture, Maya was never going to get out of there. And it was likely that Maya was going to end up in some kind of foster care and in some situation where she would be even worse.
Objection.
That's in the
Legal basis?
The legal basis is the immunity. We're not responsible for it.
I've already instructed the jury on that.
She knew if she did not take herself out of the picture, that it was likely, it was a probability that her daughter would die. The best hope would be that her daughter lived, but was with some foster parents who did not understand the disease, or was placed in a situation where she was going to be in psychiatric care. And the rest of her life, Beata knew, because she was a nurse, that Maya would be followed through her entire life, dogged by these allegations that somehow there was a psychosis going on. Afterwards, Dr. Tepa Sanchez writes and says, she's talking to Dr. Laura Vos at this time, I learned today that Ketamine Girl's mom committed suicide yesterday. Sorry to say my prediction was correct. That means it had happened before. They knew about it, and yet they still kept the pressure on. They still kept the pressure on Beata. Oh my God.
Yeah, in my opinion, that's what sinks them. That's what sinks them is that they were predicting it. They were talking about it. It had happened before when Dr. Vose was in, I think, her residency at the same hospital. They had a parent take her own life. And if you believe Dr. Tepa Sanchez's testimony, that works against them. Because Dr. Tepa Sanchez says that after meeting, I'm going to take poor Maya off the screen for a second. After meeting Beata for like 10 minutes, Beata said something to her like, oh, I just want to be in heaven. I just want to end it all. I just want to be dead or something like that. That even puts them on notice further in time from when she took her own life, that it was a possibility. And they kept pushing and pushing and pushing her. So they were on notice very early. And I think Tepa Sanchez's testimony sunk them on that. Because I'm sure the jury remembers that. I do. Do you? Yeah, foreseeability. Exactly. Is it foreseeable that this mother was in danger of taking her own life? Was, if you believe Dr. Tepa Sanchez, and Tepa Sanchez only cared for Maya within like the first, you tell me, how long was she in the PICU? At the most 48 hours, that's how long Tepa Sanchez cared for her. Maybe it was 24 hours, right away. Right. Also telling Maya that Beata was in a mental hospital and crazy, and Kathy, and that was Beatty who did that. And she is admittedly a hospital employee. Right. Telling them to get divorced.
They still thought somehow this was the right thing to push Beata to the edge and over. They knew she was on the edge, and they kept up the pressure. There's no question but that this suicide was caused directly by their actions. On the verdict form, what you're going to see is a few things, but one of them is there's two bases. And you heard Dr. Richards testify about both of them. One is, was it a substantial factor? Were their actions a substantial factor in the suicide? I submit, absolutely. The second was, did she operate from an irresistible impulse? The irresistible impulse in this instance was the maternal instinct. There was nothing she could do about it.
Tell me what you think. Do you think their actions, the hospital's actions, remember, this is the hospital is the only remaining defendant, whether the hospital's actions were a substantial factor in Beata taking her own life? What was the second part of his argument?
I submit, absolutely. The second was, did she operate from an irresistible impulse? The irresistible impulse in this instance was the maternal instinct.
And was her maternal instinct an irresistible impulse? If you agree, if your answer is yes to both of those questions, then you find the hospital liable for her wrongful death. Some people might have a hard time making the jump to get there. Some people might not. Yeah. I mean, listen, a lot of us in the chat, my audience is, I think, 92% women. A lot of moms, a lot of grandmothers. And the demographic of my audience is also, I think, like 80% 45 and up.
There was nothing she could do about it. She knew if she didn't protect her daughter here, she was going to lose her daughter. And Beata knew also, she thought through the effect of her being out of the picture. She knew it'd be tough on Kyle. She knew it'd be tough on Maya and Jack. But she figured having Maya alive was better than losing Maya. She knew they could get through somehow. But she could not stand the thought of losing her baby girl. Please take care of Maya. Don't make her suffer anymore. She doesn't deserve that. No child deserves that. Insofar as the verdict on suicide, I request that you check, yes, it was caused by them. And it's important, very important, that you answer questions 45, 46, 47, 48, and 55 in the positive if you want a recovery for Jack and for Kyle. These are the causes of action for wrongful death, and they are allowed to recover based on being beneficiaries of the estate. So that if you want to award damages to Jack for the loss of his wife and to Kyle for the loss of his mother, then you have to determine that there was an intentional infliction of emotional distress.
I have to say, Ray says I keep wavering on this, although I understand I was wavering on it too. I've been wavering on it since the very beginning, but the way that he just put that, I think tipped me over to that side. Were the hospital's actions a substantial factor in Beata taking her own life? And did she act on an irresistible impulse? And he suggests that the irresistible impulse is the maternal instinct. And then it all made sense to me. And under Florida law, if that's all you need, because if that wasn't all that he needed, you can bet there would have been an objection there.
And under that definition, by any definition, this was emotional distress that was absolutely outrageous. You just don't do what they did to a little girl like this. You just don't take away a gift. You don't tell her that her mother's crazy. You don't tell her that her mother is in a mental institution. You don't pat her. And you know what? They were patting her. Beatty would come in and pat her on the way in and way out. She was trying to develop evidence so that she could say, oh, she never reacted to that. She must not have had allodynia. That's why she was doing it. You don't put a child on your lap. You do not cuddle with a child, and you sure don't kiss a child. There was no authorization whatsoever, and Maya loathed Kathy Beatty. Remember the attorney, Zimmerman, who said it came off in waves how much she disliked Kathy Beatty. Maya did not consent to anything, and what they did was continue to put the pressure on all the way through this. So let me talk a little bit about your verdict form. There's so much to talk about in these cases. It's easy to get bogged down on it. Under false imprisonment, your claim 1, I submit there's more than enough evidence to show that they were falsely imprisoned. Maya was falsely imprisoned on the occasion of October 7th through October 13th. And then you're asked to put down damages for her pain and suffering and for mental and psychological expenses and the reasonable value of hospitalization. And that question is repeated several times through this on each one of the first two claims. What I suggest you do in trying to determine exactly how much to award is that you make a determination of the gross amount of pain and suffering, loss of capacity to enjoy life, mental anguish, and you determine the big picture, because you're going to have to determine that for intentional infliction of emotional distress and malpractice, okay? And then you go back and you assign a percentage of that to each one of these events, because each one of the events are set out separately, and you're supposed to award damages separately. Now you have in your records there, you've got the $10 million plus for Dr. Bifulco's plan, for his life care plan. And that then is spread out among the first two based on the percentages that you see are the most severe. If you determine, for instance, that the January 6, 2017 incident where she was stripped, pinned down, photographed against her will, if you determine that that one is one of the most severe, you would put the highest percentage for it. So do the math first. Figure out, and Nick's going to give you some ideas about this. Figure out using and we've got the
They came out. They said we can't do the math because you didn't give us the numbers.
Formula in there. Figure out the number of days that she was down. Remember how we had them fill out all of these forms to tell you how many days per week that this was really affecting them. And then you need to talk among yourselves and figure out an hourly rate. Now, we use hourly rates for a lot of different things in our lives. And this is the best way we have come up with for you to measure what happened to them. So you would take the hourly rate that you determine, and Nick's going to go over the remainder of it, but you're going to multiply it out against the amount of years left, which will give you the amount of days. I'll let him talk about it. But then what we want you to do is come back and give a percentage as to each one of the events. And that way you'll be able to capture all of them. And there's an instruction there about don't duplicate. This is a good way of making sure that that does not happen. It's if you use it by percentages after determining the entire amount of pain and suffering, loss of capacity to enjoy life, mental anguish. So you have a series of questions in your first few pages about false imprisonment, and you'll be asked about how to give the numbers for each one of those. Then you've got battery, and it is the battery for the psychological, whether they committed battery on Maya Kowalski on January 6th. I think everyone here agrees from the testimony that Maya was battered. And then, like I said, you have separate questions there, right, for the damages. Then it's a second one on claim 2, battery, hugs, kiss, and pats. In this instance, we're talking about.
Okay, so we're going to skip ahead to Whitney telling them how to calculate it, and let me know what you think about this hourly rate idea. I don't really know how I feel about that, but let's get to his portion of this.
That.
So last time I had to do this, he gave me a whiteboard and I sat right there and had to scribble it out. And this time he gave me about 12 hours notice. So it's time to do some math. And now he's left me 10 minutes to do it with you. So here we go. I'm here to give you, it's a difficult task to decide what justice is here for the Kowalski family. So I'm here to give you some formulas using that $100 an hour figure based on the testimony of Maya and Kyle and Jack. And I'm going to put some big numbers in front of you. That's what justice requires here. So we'll start. First, I want to take a look at the verdict form, claim 2, battery, which is page 8.
Julia says, you go into the other chats, though, the local news for one, the comments are terrible, almost like trolls. Yeah, I know. I've been there. I've seen it. I know you guys have seen it. It's toxic. We figured that out early, and that's why we all came here. at night anyway to kind of debrief this on the nights that I do it. So yeah, I hope none of those people or like-minded people are on the jury, because that would be terrible. I feel like, I know, sometimes I feel like we're in the minority. I feel like we're in the twilight zone. 100%. I would like to hear from the men in the chat. I know there's probably not a lot of men in the chat, but tell me from a man's point of view, because we are mostly 92% women here, whether you think Beata's taking of her own life can be tied back to being the hospital's fault based on what he just said, or based on your watching of this trial or anything that you've seen. If you would put a Y in the chat, and we'll say why if you think yes, Beata's suicide was caused by the hospital, or no, Beata's suicide was not caused by the hospital. We're not going to attack you, we promise. It's a hard
And I'm
claim
looking
to
at
prove.
question
I know.
18. No, January 6, 2017, you have conclusive, uncontested evidence in the record that on that date, there was a battery of Maya, and over her objection and tears, Catherine Beatty admitted that unfortunately they went ahead and did it at the direction of risk management. And question 18 is where you award damages for each of these categories. That's why I'm focusing on each of these. You make separate calculations. Pain and suffering is its own. Mental anguish is its own. Loss of capacity for the enjoyment of life is its own category. And each of them are going to be calculated for the past and future. And I recognize some of you probably have mathematical skills better than the others. So I'd ask you to lean on those folks as you're back there with a calculator trying to figure this out and do what you need to do to deliver justice. So let's go through some examples of how you would calculate for each of these categories. If you pull up slide 57 to begin. What this bucket of different categories I've just described here and pointed out to you, we've called them human damages. And so we're going to talk through not all of them, because you have to do this for each claim. There are 2 separate battery claims. There are 3 separate false imprisonment claims. There's intentional infliction of emotional stress for Maya. There's medical malpractice. For each of these, you have to do this calculation. And then, as Mr. Anderson was saying, once you come up with your total figure, then you decide, this PTSD and what Maya's suffering with, 50% of this was due to, and it really focused on this battery on January 6th. I don't know. That's your job. That's your job to allocate once you have this final number. If we go to slide 59, please. I'm going to show you the first calculation here. All right. Maya Kowalski testified that she experiences and has experienced mental anguish 15 hours a day on average if you take a good week and a bad week. Since this horrific saga ended at Johns Hopkins Children's Hospital, it's been 6.82 years. You can check our math on that. That's to the day since she was discharged. And if you apply the rate of $100 an hour to her past mental anguish, you get to this figure of $3.7 million. That's the past figure. That's the past mental anguish. Mental anguish is one of the categories under battery for the question 18. Now we have to do the same thing for the future. And you'll have the life care tables back there with you there at the mortality tables. Exhibit 2060, there's page 002, and there's pages 47 to 50. So you can check that our economist, when she came in here, and what we're representing to you is Maya's life expectancy from those mortality tables. So we do the same math. We take the hours per day that Maya experiences mental anguish. We take the days per year. We take the years remaining in Maya's life, and we multiply that by $100. And you get a figure of $34.8 million for Maya's mental anguish. And if you go one more here, you'll get a total for her past and future mental anguish. Then you allocate that among the different claims. If you'll back up to slide 55, please. We have, in addition to the human damages, we have economic damages. And these are directly from the testimony of Christy Kirby, the economist, and the life care plan. This is when I was writing on the whiteboard over here. If you go to slide 56, this is the essence of what Christy Kirby told you. At a wage or an annual earnings of approximately $100,000, which we would submit to you underestimates Maya's potential before this all happened to her. The loss of earning capacity is $5 million. And then you have future medical expenses. And this was based on the testimony of Dr. Bafolko and then Christy Kirby coming in and giving you the present value calculation. $10 million. So now you have economic damages to Maya Kowalski of $15 million. And you'll see this ability to compensate Maya Kowalski for her future medical needs and her future loss of earning capacity in several different places. For example, you'll see the ability to compensate her for future medical expenses in question 17 on the verdict form. Then I need to go to the verdict form for just a moment to look at question 34 and 36. And Mr. Anderson discussed this for a moment, but to unlock your ability to compensate and deliver justice, not just to Maya, but to Beata and Jack and Kyle, you need to answer yes on question 34. That Johns Hopkins All Children's Hospital, through its extreme and outrageous conduct, inflicted severe emotional distress on Beata, even before her death. You need to answer yes to that question. And then you'll advance to question 36 on the next page. And question 36, you need to answer yes. And if you answer questions 34 and 36 yes, then you have the opportunity to do justice for Jack and Kyle and Beata. If you answer no to those questions, 34 and 36, you'll only be compensating Maya. Having checked yes on questions 34 and 36, now we have to discuss what the wrongful death damages. So if we go to slide 63, please. We're going to talk first about Beata's loss, what's called loss of net accumulations. And this is just legal jargon for if Beata had survived this onslaught, how much would she have earned through her wages as of the time of her death in 2016, adjusted for inflation, adjusted back for present value. This is the number Christy Kirby gave you, $653,000. Then we go to Jack's wrongful death damages, slide 64. There are two categories here, and I'm going to direct you to the jury questions, which are at 40 and 41. If we could put those up for just a moment. Sorry to switch back and forth on you here. All right, right there. Questions 40 and 41. The damages for Jack Kowalski for the loss of Beata. He has two primary categories. The first is the loss of her support and services. This was, again, a number that Christy Kirby calculated for you based on something like a wage of $20 an hour for her helping to get the kids to figure skating or taking them fishing or doing laundry or cooking, those types of things. And that number I'll show you in a moment. I also want to show you that under 41, you get to compensate Jack Kowalski for the loss of Beata's companionship, what Mr. Anderson was just referencing about not being able to wake up next to his wife. So if we go back to slide 65. All right. As I mentioned, Christy Kirby did the math. I said $20 an hour is $20.10 in the past, $24.87 in the future. Total services lost by Mr. Kowalski due to Beata essentially being a good spouse and helping him around the house, $801,000. That's fairly simple. Next slide, loss of Beata's companionship. Now we get into calculations that are similar to what we did with Maya for her human damages. Jack has shorter life expectancy. We're using the same $100 figure. So the numbers are a little bit lower for Jack because fortunately he doesn't have as long to live. So if we show here the past calculation, he testified again to 14 hours a day. We get $3.4 million for losing Beata's companionship. And then if we go to the future, again, this is based on the mortality table. Advance. 19.4 years remaining in his life expectancy. We get a figure of $9 million for his future loss of Beata's companionship for a total of $13,398,000. Again, the $100 figure is up to you. The hours per day is up to you.
I think that's what the jury wants, is they want a copy of Whitney's PowerPoint presentation. I guess they weren't taking notes during this part of the trial.
Judge the credibility of the Kowalski family.
But of course, they're not entitled to it because it's not evidence.
And you go back and you look at your notes as to what they testified to hours per day, and you arrive at the appropriate number. You have to do the same thing. I'm not going to show you another calculation, but in question 41, loss of his wife's companionship is one category. Pain and suffering is a separate category. So you would do a similar calculation for Jack's pain and suffering. Let's advance to slide 68. Having done those calculations at $100 an hour, this is the figure we suggest to you for Jack's wrongful death damages, $26 million. Now I'm going to show you how to do similar calculations for Kyle under the wrongful death claims, which would mirror what you would do for Maya. So if we go to slide 73, and then 74. Now, each of Maya and Kyle have, it's not the loss of just companionship, it's the loss of parental companionship, guidance, and instruction. It's not having their mom around to bake with or take them to figure skating or help them with their homework, teach them piano. This is what Kyle testified to.
Really? This is what they choose to show right now while they're talking about loss of parental care and guidance damages. Law and crime is really not on my. I'm not really happy with them. This is terrible, and this is why the Koberger judge said if we have cameras, and I think they're going to have cameras, I'm going to control what the cameras are allowed to focus on because this is ridiculous.
Kyle's a little more stoic, quiet. He testified to 8 hours per day. So we do the same calculation for the past in much the same manner we did it for Maya Kowalski. And for a loss of parental companionship, we get to $2 million in the past, and in the future, over his life expectancy, not having a mom and thinking about those 3 months for the rest of his life and that day that he saw his mom in the garage. $17 million. And then total for Kyle Kowalski, and this is your only opportunity to compensate Kyle Kowalski in this lawsuit, $19 million. So, and then we could advance to slide 77. I'm sorry, 76, please, if you could. Is this 76? All right. Having performed those calculations for the two categories available to Kyle in this lawsuit, we submit $36 million is a starting point at $100 an hour. Next slide, please. And then we would total up the wrongful death damages. You know what? I'm going to skip these. Go to slide.
Yeah, I want to skip it too because I can't stand that they're focusing on his face. Just go to the end.
The basic. We're here to tell you that that's at $100 an hour. We're here to tell you that that's at $100 an hour.
Okay, so the total damages that they're asking for based on all these calculations.
We're here to tell you that that's
is $238,237,978 down to the penny. Let me know what you think about that number.
It's at $100 an hour. There's a movie called Onward. The basic plot is it's an animated Pixar film. I have kids 10 and 7 myself, so I watch more of these films than I hope to. Two boys lost their father, and they spend the movie attempting to bring back their father for a moment through magic and spells and a treasure hunt. And at the end, they're successful. The $100 an hour figure we submit to you, if any of these three had an opportunity to pay $100 for an hour with their mom or their wife, they would do it. They'd pay $1,000 an hour. We don't think $100 an hour is appropriate. We ask you to deliver justice for the Kowalskis.
Are you concluding your first part of your closing arguments?
That was rough. That was rough. What say you, my friends? What say you? Yeah, they're asking for those tables, but they can't have them. They're not evidence. So what do they need? What they want is they want Kirby's report. She's the economist who testified. I have her testimony queued up if you want to watch portions of it, but she goes through all of the calculations and how she came to the numbers for the future medical treatment that Maya is going to need. So that's what it's based on. They want her report. They're not going to get her report because it was not admitted into evidence. And so they're going to read back her testimony tomorrow, provided that they can get an overnight transcript from their private court reporter, I guess, that they hired to be there during the trial, because I don't think that the court reporter that is in court wants to work for them in an overnight fashion. Yeah, boogeyman. In my country, they would get around 10,000 each. Yeah, it is weird. You know, a lot of countries do not permit negligence cases at all. Like, for example, if you're on vacation somewhere like the Bahamas, Jamaica, and you get in an accident at your resort and you slip and fall around the pool, guess what? They don't have negligence causes of action there. You can't sue anybody. So yeah, to people outside of this country, this is a very strange concept. There is no negligence cases in a lot of countries in the world. So, you know, I just don't know. With the state of the economy right now, a lot of people are struggling. I don't know the financial position of the 6 people that are sitting on the jury that are going to start crunching these numbers. And I just don't know. You tell me what you think. I mean, look, he started to talk about that movie Onward, and then he never really made a connection there. And I don't think I've seen that movie, so I'm not sure what his connection, but I think he just got overwhelmed with emotion and he just couldn't finish his thought. So, you know, I don't know. I don't know about the number. Yeah. Well, Christine Hutchings says the award should be higher than 240 million, double or triple. Right. You have to think, like, how much would somebody have to pay you to take your mother away? There's no amount of money. There's no amount of money that can bring Beata back. There is no amount of money. Right. Exactly. Green-eyed Southern girl. I haven't seen it either, but if I could have my mom back, I would pay any amount of money. Yeah. Oh, watch the movie. He tied it in perfectly, says K2. I think the jury wants to send a message. You know, if they want to send a message, that's a different story. Oh, I see. HB. No, the connection was in the movie. They got their dad back. In real life, you can't. Okay. All right. I don't think I saw that one. Jen Christie says Onward is about kids that lost their dad and they tried a bunch of things to bring him back. All right. Do you guys have the stomach to listen to a little bit of what Shapiro had to say with Sally Smith about Sally Smith and then some causation arguments? I could speed him up if you want, if it's going to be too much, but I think we need to give him a little time here. And let me know what you think about his demeanor and about what he says. Not that we have to give equal time to both sides, but he's representing his client, and we'll see if we think that it flies.
If you want to know whether this is standard of care, look back at Tampa General, Defense Exhibit 30470674.
Wait, that's really on high speed. He must talk really fast. That's only on 1 1/4. Is that too fast for you guys? That sounds really fast to me, but we'll see if you think it's too. Yeah, people are like, I can't listen to it. All right, so we'll go fast, and if you want me to slow it down, tell me.
They did the same video surveillance monitoring there too. The Kowalskis are not suing for invasion of privacy. They're suing you for false imprisonment and wanting to know, the jury instruction on this, and go to your package, is whether all children had authority and consent. Where's the restraint? Where is the restraint on this? Where would punitive damages even be considered involving a false imprisonment of intentional misconduct when they're putting Maya in the same room as any other room to check her true abilities, combing her hair, bringing her in and out of the room for different therapies?
He just admitted they put her in there to check her true abilities. They were crying at normal speed? All right.
On the balance of probabilities, the only thing you've ever heard is Mr. Kowalski tell you that some unidentified person threatened him with arrest. That's it. And on the other side of the scale, you have the signed consent form, 5, 6, 7, 8 notes agreeing with the plan of care. But you don't have to listen to our records. You have Beata's email and evidence. You have Mr. Kowalski's voice and evidence. And this EEG room is identical to others. And that's important because when you look at the judge's instruction on what false imprisonment is, the person has to know they're being restrained. The person has to know they're being restrained. And if Maya doesn't see a difference in the room like any other room, they can't prevail on this count.
Okay. Oh, he's talking about the EEG room.
Let's talk a little bit about Dr. Sally Smith.
Let's.
This part's undisputed. She has no orders in the chart. And by the way, this is actually quite important. So let's make sure everyone understands. There's obviously, and you've seen so many sidebar conferences about the dependency courts, not part of this action.
Wait, stop. Lois Smith. Apparently it was bring your family to work day. Shapiro's wife and kids sitting in the gallery. The wife was rolling her eyes when plaintiff presented closing arguments. She's the one that was in that's in that Facebook group that's been posting all kinds of crazy stuff. Tell me what she's wearing. So next time they show the gallery, we know who she is, because that's really interesting. I mean, I can't believe. I mean, everybody seems to know about it. Everybody in every chat seems to know about it. How her husband didn't tell her to knock it off.
Right? You've been told over and over again, All Children's Hospital is not responsible for the separation of Maya from her family. We are not being sued for anything that Sally Smith did in her role on the child protective side. It's only if you think that she did something on the medical care and treatment in the hospital you could hold us liable for. So if you're in the deliberation room wondering if you're checking the box for Dr. Sally Smith, and I would implore you not to, and I'll show you why. It would have nothing to do with went on in dependency.
Okay, is this his wife right here? Anybody know? Yeah, people will tell you in the chat what kind of things that she was saying in these crazy Facebook groups. Like she's been trolling. If that's her, I don't know if that's like, I don't want to point her out if that's not her. But people said it was like going to a wedding. It was like this side of the courtroom were all for the defense, and the people sitting on the other side were all for the plaintiff. Oh, she had kids with her, Dee says. Behind bald man with facial hair. Oh, that's Dr. Malik, isn't it? Okay, so this is her in the green. This is her in the green shirt. Okay. Because I see this is Tepa Sanchez, right? Over here with the glasses on. Where's my cursor? I guess you can't see it on there. And then this is Dr. Malik. I think that's Dr. Malik, right? With the goatee and and then this woman also testified in the white blazer. Okay. All right. Now we know who to watch. Thank you, Ashley PG.
That's not part of this. She never directed treatment. She made suggestions for what she needed, and you heard from Dr. Alexander that All Children's absolutely has to cooperate with the CPT investigator, that at all times, Dr. Sally Smith was acting in her role as a CPT investigator. The idea that there's something improper about our hospital, our employees who care, calling Dr. Smith on a, what do you think? Given what we saw in the ICU, including the statements of talking about terminal hospice, that they're going to pick up the phone and say, hey, you've been at this for a while. What do you think? Would they prefer the standard of care be like just call the abuse hotline every time? This is exactly what you want people to do.
Wait, so what did you do? Did you call the abuse hotline? Because you called it like 3 times. The first time you called, somebody said there was no answer. The second time you called, they dismissed the complaint because they confirmed the CRPS diagnosis with Dr. Kirkpatrick. And then they called Sally Smith in to, to be the hammer. So which is it?
Do in the situation. And again, on the question of apparent agency, we got a document. So this is going to be helpful. Again, plaintiff's exhibit 2408.
Well, so when they need the documents, they're able to find them. But when they're court ordered to turn over documents, all of a sudden they're in Dracula's files somewhere in a locked cave in a casket outside sunlight. But now he's got a document, and he wants the jury to rely on this document. But don't rely on all the documents that we couldn't find and didn't turn over and held until the last minute when Dr. Corcoran had to miss a medical procedure, by the way, that he was scheduled for that day, to spend a couple hours looking at all the banker's boxes full of documents that you suddenly found.
They've told you we had no idea who Dr. Smith worked for. Beata Kowalski to Beata Kowalski and Jack Kowalski. October 11th, I had another supersized visit from MD Dr. Smith, who was sent by Child Protective Services to investigate.
Okay, tell me what you think about this email. So he's showing an email that is sent from Beata on Wednesday, October 12th at 9:27 p.m. to herself and to Jack. And she says, because the 13th was the day that they were in court, that the judge took away custody and stripped them of their parental rights and forbade Beata from having any contact with Maya. So just because she says on the 11th that by then she knew who Sally Smith was, right? Because she had to hire an attorney to represent them in that proceeding. So I'm sure the attorney knows Sally Smith very, very well. And that's how she probably found out who Sally Smith was. She didn't find out from the hospital or from Sally Smith that Sally Smith was a CA pediatrician sent by CPS, but it's really DCF in Florida. So I don't know if that's going to fly, that argument. Let me know what you think. Actually, it goes to 1013, the false imprisonment claim. 10:7 to 10:13. And she's saying by 10:11 she knew. But okay, so maybe she knew by then because her attorney told her.
The question of apparent agency arises in terms of what the hospital held out and what the Kowalskis understood. It's right there. This is an easy one for you to check the box on.
No, it's not.
Let me transition back to the medical care. If there's a document that I believe you should spend time on, it's the neuropsych report of Dr. Lewis because it answers a lot of questions. Not the doctor from All Children's Hospital, okay? He met with Maya and submitted a psychological report on October 18th, 2016. We can walk through this.
All right, he's going to just say a lot of other things that are going to annoy us, but I want to get to the causation argument that he has.
Visit in that period of time, other than a broken finger, which they're obviously not claiming is the fault of anybody, for which she sought medical care, I believe 48 hours after the injury. Other than that, the only hospitalization was related to stress. So when we talk about causation, for the plaintiff, they first have to prove on medical malpractice we were negligent. And we believe the overwhelming evidence is that All Children's practice, the evidence-based medicine that was proven to work at multiple institutions, but they have to do what is in your jury instructions as the but-for instruction, right? Makes sense. They have to be able to tell you that had it not been for All Children's, Maya would have been better. They brought Dr. Bifulco. And if you check your notes and if you were listening carefully, Dr. Bifulco made 3 critical concessions that, from the defense's standpoint, cannot support any verdict against All Children's Hospital on medical malpractice. Not just because we didn't commit medical malpractice, but because he was asked directly. And he could not testify what Maya was going to need but for her All Children's hospitalization. He could not testify as what she would need from a psychological standpoint, but for All Children's. He made no determination about what she needed. He was just saying, she's got CRPS, this is what she needs. Dr. Chopra told you it's a lifetime condition if she has it. And then at the bottom, he made the recommendation for $3.7 million in ketamine. And I said, Dr. Bifulco, where is that coming from? Dr. Kirkpatrick. Why are we going backwards? Why would we, with all of the progress that Maya's made, her bravery, right? I mean, truly, in the face of tragedy and losing her mom and going home, and through, the shepherding of Mr. Kowalski to help get her healthy, we'll talk about that a little more, Why are we going back on ketamine? Do not award millions of dollars for ketamine. Dr. Levy was brought to answer that question. She is the director of adolescence and substance abuse addiction at Harvard. You didn't need to hear from her about whether.
We didn't need to hear from her at all. We did not go over her testimony together, but she was one of the worst witnesses I have ever seen. This woman testified, and if you haven't watched her testimony, go back and watch it. Figure out what day it was. She did not review a single thing. She came onto this Zoom as if she had no idea what this case was about. She doesn't remember anything. I mean, her testimony was terrible. I can't even believe that he's going to bring her up in his closing. That's how bad it was.
Ketamine can cause hallucinations and mood disturbance. You heard it from Beata. You didn't need to hear from her about the short-term memory issues. You heard it from Beata. But she told you what would happen to the developing brain if you started exposing it to ketamine again and again and again, as in Dr. Bifocal's life care plan recommended by Dr. Kirkpatrick at $12,000 for a week. It would cause addiction problems and potential neurotoxicity. And by the way, when we talk about memory disturbances, if you look back at what they are alleging at All Children's Hospital, and this is really important, almost everything, if not everything, that they're alleging against Miss Beatty is based on Maya's memory, isn't it? And Mr. Kowalski testified that he didn't personally observe anything untoward. The people who came into the hospital, whether it was the teacher or the guardian ad litem or the people that are not affiliated with the hospital, no one saw it. It's all based on the memories of a 9 to 10-year-old child in the hospital who, by her own admission, was, when she disclaimed the care book, told you I would say anything I needed to get out, including telling these nurses that I liked them, even though I didn't like them, which is understandable. Who would want to be in the hospital away from their family?
Now he's gaslighting anybody who's ever suffered childhood trauma. Ooh, did you catch that? We're supposed to rely on the memory of a 9 or 10-year-old girl? Of course she doesn't want to be there, but all of these other traumatic things that she's now testifying about didn't really happen. He just gaslit every single person who's ever suffered from medical trauma as a child. Did anybody catch that? Has anybody here suffered from a childhood trauma, and would you say that your memories are false? Let me know what you think in the comments.
But that's what it was based on. Those memories from that time. I'm going to handle a topic as sensitively as I can.
Wow.
The plaintiffs called it.
That's like when somebody is about to lie to you and they say, to be honest, or wow, I'm gonna handle this as sensitively as I can. Okay. Yes, we did hear that, Lois. Lois Smith says, anyone else hear Jules, the courtroom observer, saying that Shapiro told her to get a life? This guy and his wife are not decent people. Not only that, Villa Ray called in yesterday, and she was in court yesterday, and she saw that interaction take place. She watched it happen. She couldn't believe it. He said something to Jules like, so what are you going to do after this trial? Are you going to get a life? And she said something back to him like, I don't know. What are you going to do? Are you going to ever get to go on that vacation or something? Wow. Okay. Thank you, Dr. Edward Moskowitz. They are true. Children don't make up stuff like that. No, they don't.
An expert, Dr. Scott Richards. We had a little bit of fun, right? Maybe it wasn't fun, but yours, Mr. Anderson's frat brother, swim teammate, and he told me, well, we listened to different music. We were in different parts of the frat. But he's the sacrifice he's talking about. When I tell you, when you listen to experts and you can use your common sense, right? It doesn't go out the window. The suicide, for better or for worse, was a result, was it not? Doesn't your common sense tell you about her being separated from Maya, for which this hospital is not responsible? You don't need an expert, especially someone who's never evaluated Beata. When you're looking at the instruction, when they're trying to hold my client liable for a suicide, when all we were trying to do was protect Maya, when all we were trying to do was provide evidence-based approaches for therapies that we believed could heal her. What was the extreme and outrageous conduct that they proved through their burden that all children did? What was it? When you're back in the deliberation room, what was it? The phone call that was Charlotte Laporte, the confiscation of communion that was Tori Neus, having a child on your lap? That's a fact.
I would submit to you, yes, that is extreme and outrageous conduct. Kathy Beatty putting her on her lap, kissing her, telling her mother that her mother is in a mental institution and that's why she can't see her mother. Telling her, don't worry, I'm going to be your mother. If the jury believes those things, 100%, that's extreme and outrageous conduct. Come for me in the comments on that, you guys. Come for me in the comments, respectfully. That is extreme and outrageous conduct. And if you agree with me or don't agree with me, let me know either way. Come for me in the comments. I have merch that says that. But yeah, it's extreme and outrageous. How dare he stand there and tell us that? I have a bigger screen over here, which is why I'm looking here because my eyes are not great. Hi, Chastity Tyler, and thank you so much for your super chat. Tonight, Jules said a member from the Joint Commission was there today observing, and he said he wasn't ready to make an official statement yet. That's interesting. That's really interesting.
Factor that can be used to say suicide. The uncontrollable impulse, and because there's family here, I'm going to be brief. You've seen how that act was carried out. It wasn't instant in terms of the setup, but there's notes, and the most important.
All right, I'm going to read this note in case you haven't seen it, because he's not going to read it. And this is an email from Beata to Beata. So this was on January 6th. This was the day of that fateful court hearing where the judge would not allow Maya to give her mom a hug. Subject is goodbye. Thank you for all your support. Please take care of my Maya and tell her how much I love her every day. Please tell her I will see her in heaven one day and we will be united forever. Please tell Kyle also that I love him very much and I hope that he grows up to be a good man and has a great future. Until then, please take care of Maya, but don't make her suffer anymore. She doesn't deserve that. I give the right of my parental rights of Maya to my sisters and brother in Chicago area. Please take care of my children. My final wish, please cremate me and give my ashes to my children so I can be close to them anywhere that they choose to go. I love you very much. And then there's something that's blocked by the logo there. And that was the night that she took her own life by hanging in the garage of the family home.
One is the one that's at Exhibit 3212. Beata Kowalski, moments after the judge denied her the right to hug her child. We're not here to argue about the dependency court. It's a separate issue. Okay? This note was penned now, what, 3.5 months? I think the plaintiff said 99 days or 107 days after no contact with her daughter. It's not from placing a child on her lap. The letters to.
Okay. He doesn't want us to believe that, but he wants us to believe but for causation. And we've talked a lot about but for causation. And I'm going to submit to you the following. But for the actions of the hospital by making, the first call to the CA hotline. The first call was dismissed. But for the actions of the hospital by making that second call after they had no good faith basis to do so, based on the fact that CRPS as a diagnosis for Maya was in their chart, in their computer. She had been treated there before. They had inserted a port in her body for her K infusions that they knew she was getting. They confirmed the diagnosis with her treating doctors. But for the actions of the hospital, this never would have happened. So you can't tell them you want them to, apply but for causation in one area of the case, but not in another. The jury is smart. We've heard their questions. I'm going to read you this email now. This is also from Beata to Beata, same date, January 6th. And this is to the judge this time. And it says, Verinia, please give this letter to Judge Hayworth on Monday when you return to work. Thank you. Dear Honorable Judge, your heart is made out of iceberg. ACH, DCF have destroyed my daughter physically and mentally. You let them continue to destroy her even more, slowly each day. My daughter will never be who she was before October 13th of 2016. By taking the side of ACH and DCF, you have destroyed my family, my marriage, you have put us in bankruptcy, and you still denied me to see my daughter in court today and have face-to-face visitation with her. I hope that every time you lay down to sleep at night, you will think of what you ultimately have done to my daughter and my family. I hope you will take responsibility for my daughter's physical deconditioning, worsening of her CRPS that eventually will lead her to slow, painful death. I hope that in the end, you will take responsibility and make my daughter healthier and better, since you have completely bleeded us out of money, and pretty soon there will be only one income coming in to support my family and pay the attorneys. How's he going to spin this email?
To the judge. Oh, and by the way, the response at the end, I hope you will take responsibility for my daughter's physical conditioning, worsening of her CRPS that will eventually lead to her slow and painful death. Where'd you get that? Remember? Dr. Kirkpatrick. Who put that idea in her mind? Not all children's. And by the way, he tried to backpedal, didn't he? Pulmonary embolus? You know what that is. God. That's not what he's talking about. Put in Mrs. Kowalski's mind that if she didn't get his ketamine, this would happen. Shame. And then the final note that was now written. This one's now, if you look, just in terms of the time, and I don't want to belabor this point any more than I have or I need to. January 6th, 3:57. Now we're to January 7th at 10:59. 30 plus hours have passed. This is not an irresistible impulse. Not an irresistible.
I want to read that email because it's a different one than the one that we read before. And this is, again, to Beata from Beata. Subject is goodbye. Thank you for all your support. Please take care of my Maya and tell her how much I love her every day. Please tell her I will see her in heaven and one day we will be united forever. Please tell Kyle also that I love him very much and I hope that he grows up to be a strong, good man, has great future and stays close to God. Until then, please take care of Maya, but don't make her suffer anymore. She doesn't deserve that. No child deserves that. But he wants the jury to think that these emails are not important. And that because they were written at whatever time they were written, there was no irresistible impulse because Maya had already been there for almost 90 days. So it's, yeah, exactly. Me too.
I need to talk to you about damages, and I'm going to do it briefly. All children's would not be here if we thought we owed the damages in this case. Okay?
Mr. Shapiro, you've consumed an hour and a half.
Thank you. But I told you in voir dire, we don't argue damages in separate sections. We don't see if you award liability and come back. We do it all in one part for your efficiency. If you don't agree with me, here's what I would suggest.
Okay, here's where he's going to flip the whole thing around. And this is something else that we talked about in the beginning of this case, which is bifurcation of trials. In New York, trials are bifurcated, which means that if you have a car accident, any kind of injury case, there are two trials. The first trial is on liability or fault. And during that part of the trial, the jury hears nothing about injuries. So after the jury comes back with a verdict on fault, if they find for the plaintiff, it goes to the second phase. And that's when you bring the doctors in to testify about damages. And that's when the plaintiff can get up on the stand and testify about pain and suffering. And that's when you bring in your economists and your life care planners and you show the day in the life video if the person had passed away. So it's completely different. Here, this is all one trial, and this is very difficult for someone like me with 30 years of legal experience to unpack how much there is here for a jury who's not used to threading these needles every single day and trying to unpack all of these legal arguments. But what I find so ridiculous in that is he's saying to the jury, like, we're doing you a favor by doing this whole entire trial together. Like, we're doing you guys a favor, for judicial economy. That's why we're doing it this way. I don't know why they're doing it this way. I don't know if they agreed to. It's Florida. Like, I don't practice in Florida, so I don't know.
For medical liability, but I told you in voir dire, we don't argue damages in separate sections. We don't see if you award liability and come back. We do it all in one part for your efficiency.
For your efficiency, jury.
If you don't agree with me, here's what I would suggest. For medical malpractice, the only thing that Maya would need is a tune-up on physical therapy. You heard from Dr. I don't know if it was Ms. Kirby pricing it out. You can use your common sense. If physical therapy costs $150 a session and she needs another year of it and needs it twice a week, $300 a week times 50 weeks would be $15,000. That would, if you really believe we interrupted her care by not giving her the ketamine and we're somehow liable for medical malpractice, that would be what would be reasonable. I want to talk about the photos because this is important because I know you guys are going to wrestle with this. I get it. You have the batteries were either 2 days in a room, same room as anything else, or we have my shirt being lifted.
Same room as anything else. It wasn't like a prison or anything. It didn't have bars on the windows or anything. I mean, she wasn't locked in there, like some of the prisons. For a 10-year-old, that is a prison. Okay? Okay? And he's got kids there. So they were 10 once. Just saying.
And being taken photos, 10 minutes, 15 minutes in the front end, 10 minutes, 15 minutes on the back end. If you don't like it and you disagree with me and believe she owed some money for that, then you should award something for that. And the judge's instructions, in the instructions, give instructions. And don't rely on this because these are different instructions for medical malpractice, but the general verbiage are awards should be fair and just in light of the evidence. Awards should fairly adequately compensate for the loss. They're compensation damages for that. If you believe because of the photos that Maya Kowalski needs therapy, and by the way, we think.
What just happened? Can you guys, is it just this that's freaking out over here? Can you guys still see me? Oh, that's weird. Hello, law and crime. I don't know. Must be law and crime. Or YouTube. YouTube's having an issue? My Wi-Fi is on. I mean, my Ethernet is on. No, tap back. All right. I don't know. So many people are trying to watch it. Thank you.
For that.
Like,
if you believe because of the photos that Maya Kowalski needs therapy, and by the way, we think Ms. Kirby, the inpatient therapy is $30,000 to $57,000. If you think that she needs psychotherapy for the next period of time, if it's 100.
Wait, so I haven't really watched this in its entirety yet. Is he actually saying that we don't think we did anything wrong, but if we did do something wrong, here's how much you should give?
And I want to tell you that there's the numbers they put on the board, we have to tie to real. That we would suggest that numbers from $500,000 to $1 million or $1.5 million, even per person, would be something that would be fair and.
Okay. So now he's going to say, we don't think we did anything wrong, but if you do think that we did something wrong, well, then you should give $500,000 to $1 million, maybe $5 million per person. Okay. All right. Well, that's a little bit disturbing. That's a very, very strange tactic. How about you either say, we don't think we did anything wrong, and we understand that they were injured, and we understand that it's horrible to lose your mother, your wife, but we didn't cause it, and we don't think you should award anything. But if you do think we did, then give them 5 million each instead of 200 million. Yeah, it's a lot a bit disturbing. Wow. Okay. Yeah, that's I've never seen that before. Okay. Yeah, I was going to say that too. Now the jury's thinking, "Oh, so you offered 15 million and they didn't accept it?" Okay, well, now we're going to have to really at least add a couple zeros to that. Yeah. Yeah. Very disturbing, Sandy. Him saying that. Him saying it that way proves the plaintiff's points. Wow. Okay. Well, that's on the cheap end. These Miku's headphones say it's $200 to $300 to $400 a session, and they don't take insurance if you're looking for a special. I got so mad I just knocked myself out of the screen by swiping on my keyboard. And this thing is still buffering, so I don't know what that's about. I don't think that's going to work. Oh. Even YouTube doesn't like it. Thank you. I'm back. Okay, so do you want to watch a little bit of Anderson's rebuttal, or do you want to watch the Economist? Christy Kirby, because that's what they're going to read tomorrow in court, but you're not going to see the video. You're just going to have to listen to them read it. It's been buffering all day, Steph. I saw that too. I noticed it too, and I thought it was because maybe so many people were trying to watch this stream. It's not my Ethernet because I did a speed test earlier. Anderson first? Okay. See if we can get that to even like work. All right, so he's going to make some more nonsensical arguments, right, you guys? And then Anderson's going to come on at 4:08. Yeah, maybe I have to put it on 1 speed. It is on normal speed. I don't know. I need a whole crew, you guys. I need a whole crew. It's just me. I'm just a one-woman show doing the best that I can. All right. See if it'll go now.
Needs to take a couple moments to make any last-minute telephone call because effectively this will be your last opportunity until the time.
I don't even have many windows open. Usually I have a lot of windows open.
Exactly why we need punitive damages. What you heard was exactly why we need punitive damages in this case. They still don't get it. Well, I think I heard that they agreed with some of our liability positions. They still do not understand institutionally, as voiced through their attorneys, how awful this was, how terrible it was, the things that they did here. This is Johns Hopkins. This is Johns Hopkins All Children's Hospital. This is who they really are. This is a place where they call little girls who just lost their mom ketamine girl and appear to have absolutely no problem with the fact that they knew this was coming and said nothing and did nothing. This is who Johns Hopkins is. They say, I wouldn't put anything past her mother. Put what past her mother? Trying to take care of her child?
Mm-hmm.
She can't perform this charade effectively 24/7. They're talking about a 10-year-old. Maya feels ACH is lying. Wonder why that is. What kind of doctor-patient relationship is that? What kind of pediatric relationship is that? Why would you want to keep a child there when the child doesn't want to be there and just wants to be away from you in this first week? Maya feels ACH is lying to her about her mother. that the doctors are lying about her parents. This should never even begin to start up in a pediatrician-child relationship. It should never, ever be. This is who Johns Hopkins All Children's Hospital is. It's a place that retaliates against its own employees for bringing things out that are negative, and retaliates against anyone, any parent who decides they want to do something different. All I heard on the other side was, it's our standard of care. It's our standard of care. It's our standard of care. Who cares if it's your standard of care? A parent has a right to decide their child's own treatment. They don't get to choose it. And that's a lot about what this case is about. It's about an organization that is so screwed up that it actually thinks it's a good idea to force parents to accept their way of doing things. And if the parents don't, then they've got to find different ways to punish them. That's where all this stuff came out of on the 7th. They disagreed. Beata, a registered nurse, an infusion nurse, knew what she was talking about and had 15, 16 months of experience as to what worked and didn't work, made the greatest mistake you could ever make to these people. She said no. They still don't freaking get it. They still don't freaking get it. Here are the punitive damages questions. 5, 10, 15, 20. Those are 4 opportunities if you agree with the plaintiffs that this is completely and utterly intolerable. Punitive damages are for willful, wanton, and malicious character, behavior. There's absolutely no question that risk management, with the concurrence and knowledge of the general counsel, which is as high as you can get in this, planned and instituted this entire idea of stripping this child down, taking photographs of her, not letting the parents know, against the child's will. They knew. They instituted this from the very top of this organization. What does that tell you about what's going on here? What kind of ultimate lack of humanity? There needs to be some captain of this ship, and there never was. It was totally dysfunctional, the way this hospital operated. No one was checking. No one was making sure to see how this child was being taken care of. No one was looking to see how their own employees were behaving. And it wasn't just one. Yes, it has to be clear and convincing, but when you have internal memoranda from the highest up in the hospital down to a Kathy Beattie telling her to do something like that, that's clear and convincing. That's from the highest part of the hospital down to do something despicable. You don't do that. I heard a lot about attacking Beata. I never figured out why. If they really, okay, again, pardon me if I'm confused on this. If these doctors who are all licensed and specialists in CRPS and pain control prescribed what they think was too much medication, why go after mom? Why not go after the doctors? Where have you seen anywhere where anything that Johns Hopkins did questioned the actual doctors writing the prescriptions?
That's a great question.
No, it's too hard. That's too hard. That might cause problems. Now, it's easier to go after Beata Plus, she insulted them by not agreeing with what their routine was. Think about this, though. If the whole point here is that Beata, who is just trying to take care of her child, by the way, is taking her child to places and trying to get treatment, and these doctors are prescribing all of these excess medications, or this won't work or that won't work, why are you attacking the mother? What possible good does that do? After the Mexico trip, one of their pulmonologists, who actually was a very nice man, Dr. Kreisman, saw Maya, having seen her 2 times before Mexico, and now 5 months after Mexico, and says, talking about the treatment in Mexico, the long-term ketamine infusions, this is a new child. Do we have that? This is a new child. She's bright. She no longer appears to be in pain. On physical examination, she's examined in her wheelchair. She is a completely different child from the last exam, which was 2 months before Mexico. By that I mean she is not in any pain. She is not moaning. She is smiling. She is interactive. She is very engaged. Oxygen saturation is 100%. Weight 25 kilograms. This is an experienced Johns Hopkins doctor. Remember I said there's a lot of the outside doctors I thought were trying to do their job. Apparently Dr. Kreisman was. And 5 months after, here he is saying this is a different child. That's their own physician saying that. And please keep in mind, around this time, their surgeons also put the port into her chest to facilitate the ketamine infusions. What you are seeing here is an incredible example of revisionist history, picking little bits and pieces out of the record and trying to fashion them into some blame. What did the Kowalskis do wrong here? What was the purpose of all this? Other than arrogance and the belief that ultimately they could get away with it. Forcing the parents to agree with your own version when you don't even have the doctors with the right specific skill set to disagree reeks of arrogance. It reeks of people who are not getting out enough medically, who are not keeping up with the latest trends. If they're going to be Johns Hopkins All Children's Hospital, which is supposed to be the Johns Hopkins name, one would think that they would be right on top of the very latest treatments, right? They weren't. And they relied on this Sally Smith character to come in. And she's a pediatrician. And there's nothing against pediatricians. I'm not down on pediatricians. I'm down on pediatricians who think that they're neurologists or anesthesiologists with a subspecialty in CRPS and a subspecialty in ketamine treatment and treatment for what is known as chronic CRPS. See, Maya had already been through all of those things that Johns Hopkins was suggesting, and Beata knew it. Beata knew the only thing they had within that first few hours they were questioning them. That's why tensions were getting a little high. Are you going to be able to increase the amount of ketamine for my kid or not? No? We're out of here. Wait a second now. This might be dangerous. There might be something wrong here. Now, we want to leave. Okay. Well, just let us hold on for a second and we'll see what we can do. Ask yourself this. Where were their psychiatrists? They brought in little bits and pieces of other hospitals, psychiatrists, or in one case, a nurse's assistant, not nurse, a pediatric, a physician's assistant who's a nurse to make a diagnosis or a potential diagnosis. And they brought in another instance, a nurse in another hospital who thinks this might be conversion disorder. Ladies and gentlemen, where did you see their expert come in and confirm any diagnosis of conversion disorder or any psychosomatic condition that outweighed that it was CRPS?
Didn't see it. Did anybody see it? I didn't see it. You know what I did see? I don't know, over $500,000 in billing for CRPS treatment, though. Saw that. I don't know. I don't know how you can. I don't know how you can rectify those two things. She had it, or she didn't have it. They made it up, or they didn't make it up.
They're Johns Hopkins. They can't find a psychiatrist to come in and agree with them? Nope. Attacking Beata. Why go after Beata? I guess it was easy pickings. I guess they figured, I don't know whether it was her accent or just the way she acted or what it was, but they sure did hone down on her. I can't put anything past her mother. I'm trying to, and have tried to, through this case, use videos and photographs to try to express to you how the child was doing at different stages, because I believed that you would trust your eyes. You would trust what you could see and watch. And that's still true for after she got out of there. It still took her 10 months to get back to even close to a baseline, and another 6 months of transitioning off to get off of those crutches. And she did it through hard work. And instead of it being looked at as a good thing, this is a sign somehow that they're right. They're actually taking credit for all of the incredible hard work Maya did on her own. And we all pretty much know why she was doing this. She wanted to prove something. She wanted to prove to them she could do it. It hurt like hell. She had no ketamine, no pain meds, scared out of her wits, the family. And when you read there those orders, you'll see that for the last 10 days to 12 days, the judge said, and no ketamine. Do you really think that this family was going to go back and try the ketamine that put them right back there in that power system? You think they're really going to go back to that? No. And that's why they didn't go back on the ketamine. The ketamine worked. It would have made her life so much easier, but Johns Hopkins, they ended that. You know, in the Civil War, they would cut off soldiers' arms and legs with a shot of whiskey as the anesthetic. That didn't make it good. That didn't make it state of the art. That's just all they had back then. The ketamine was there to help her get better and to help her reach the best that she could be. And they took that tool away from her.
Your Honor, I object. This is immunity issues.
Sustained.
Think of it this way. They believed, I gather, that Maya had recovered because of their treatment. What she did was have a remission. And we've spent the past 8 weeks explaining CRPS to you. It's a devilish disease. And you can go for months, weeks, months, years, you can have a change like that. Exactly what happened in November of 2020, and then again in 2022. And think about this. This is during the period of her life where her immune system is at its absolute best. What's going to happen when life starts to take a few chunks out of her? It's not a very good thought, but she's brave. I think she'll get through it, but it's going to be a lot harder on her, and it shouldn't have been, because let me get to a point on this causation thing. that the defense was talking about.
You've consumed an hour and a half total.
Say again, Your Honor?
An hour and a half total you've consumed. 30 minutes left.
Thank you, Judge. In your jury instructions, you will see an instruction on causation. And what it's going to say is that it doesn't have to be the only cause for you to award damage. It has to be one of the causes, and in the terms of suicide, a substantial cause. So you can have two forces acting and still award damages for it. And if it is the aggravation of a pre-existing condition, which in this instance would be the CRPS, you can look at the way she was before, and then you can look at after the tortfeasor, in this case, Johns Hopkins, aggravated it to see how she was after. Now, here's the key. You can divide that up if you have the evidence to do so. Typically, the evidence is where a doctor comes in, qualified physician, and says, okay, 50% of this, 60% of this is pre-existing CRPS, and 40% of this is the aggravation part. You don't have that evidence here. You don't have that testimony in the record. Under the instructions you have, then, whatever CRPS she had before it was complicated with PTSD, depression, and a failure for the first round of treatment to succeed, whatever that ended up to be, unless you can find a way to divide it up without medical testimony, 100% of what she ends up with is on them.
Object is a misstatement of the jury.
It's not. So, when you're considering back there, well, she did have CRPS beforehand, and that's a difficult disease, you know, and I don't know if we can really blame Johns Hopkins. Well, you can't blame him for her having CRPS walking in, but you darn sure can for what happened walking out. And the fact is that with the post-traumatic stress disorder, absolutely, I don't want to say earned, but imposed on her, and the depression from a variety of factors, not the least of which is losing her mother, that aggravated it and will continue to aggravate it down the road. And here's the problem. What you've seen in the November of 2020 relapse was because of a psychological factor. That's what triggered it. That was not a physical factor. When she had the relapse, right before she went in during October of 2016, that was a psychological factor. So you have what's known as a clinical history of psychological factors aggravating her CRPS, right? You had the CRPS, and now you've got an overlay of a CRPS that has been complicated because the first round of treatment was not completed. The glial cells that Dr. Chopra talked about, that was not completed. That made her more susceptible to longer, more intense, more frequent of these relapses. And then you had an overlay on it of psychological issues, not her own, caused by them, that are going to aggravate her situation the rest of her life. And like I said, she's at the top of her game now biochemically. Wait till you get out in the real world and you start to age a little bit and you start to have some things, life take bites out of you here and there. You're going to have some psychological issues come up. And she's not going to be as equipped to deal with them as she could have been. Because Beata had a good plan. Beata had figured out, very smart lady, how to deal with this. And although Maya would much prefer never to have this loathsome condition, her mom had figured out how to allow her to be the best she could be. Now that was taken from her. And so when you are back there considering the damages, I want you to consider, from Maya's perspective, how great she can be, could be, with the talent she has, her intelligence, her abilities. But to get there, what kind of stresses is she going to have to put herself through in order to get there? And then from there, how is her aggravated illness going to react? This child hasn't even taken her SATs. She's in halfway through her senior year in high school. She hasn't applied to any universities. Yeah, back in 2019, she's ready to rock. She's ready to go. Life has a funny way of affecting you, doesn't it? And after you start thinking about what you went through when you start having a relapse, you lose a little bit of initiative, a little bit of drive. If she does overcome that, though, if she does try, think about the psychological challenges of going to the type of school that she should, by all rights, go to, a top university. Think about the challenges she faces. in the type of jobs that she should be able to do. That's where those big numbers come from. And they're not made up at all in any way. And I'll tell you how I know. If they had their own Dr. Bifloco, life care planner, where was it? No psychiatrist, no life care planner. If they had their own Dr. Tremp talking about the freight way to college, which is what he was talking about before all this happened to her. If they had their own Dr. Tremp, where is he?
Yeah, and that's what's so weird too. That's a great point because, like Shapiro came out and said, well, we didn't really do anything wrong, but if we did do something wrong, here's how much you should award. Well, they had no expert witnesses testify to that. So that was a really odd road for him to go down.
If they had their own economist to figure this out, where is she? On him. If the kind of defense they put together, if there was somebody who truly was going to disagree with those numbers, don't you think they'd be in here testifying about it? Instead of having their lawyer come in and attempt to pick here and there at the sidelines of what really happened to this family. And it's not just Kathy Beatty or Sally Smith or some of those nurses, and there were some good nurses there. I'll talk about that in a moment, but this was a problem endemic to the entire operation, and that's why they were in imminent jeopardy, IG, of losing their accreditation to be able to continue to receive federal funding and get approval from the agency that was overarching all hospitals.
I was wondering when he was going to bring this up. I'd be hammering this for at least a half an hour. All right, let me make this bigger for you guys.
The industry leader there. This was an organization that was teetering and was trying to get its act together because its culture of people reporting problems was so toxic that they had to have multiple meetings and consultants and ideas of just how to fix it. And all that came well after the poor Kowalski family was involved. This went straight to the top. This ship never had a captain. And that's how you end up with these situations. It was a totally dysfunctional organization. And the Kowalski.
I've been saying this, K-Pick, since day one of this trial that it had to be unanimous. Nobody wanted to believe me either. I don't know why. In New York, it is a majority. Here in Florida, it must be unanimous in a civil trial.
Pay the price. Pay the price. We didn't take. Nick did a great job, didn't he, on the numbers? I'm not so hot on the numbers, as we know, but they tried to minimize some of the effects of this. They tried to talk things down like, well, it was only 15 minutes that she was pinned down, stripped, photographed against her will. This is a 10-year-old girl. She's ill. She has a disease that will not allow her to escape in any way. She's in a wheelchair. She's in a place that she despises around people she doesn't trust. And she's being photographed.
Yeah, the minimization of that by Shapiro I thought was gross. That's when the feed started buffering. But you heard him say, oh, it was only 15 minutes. I mean, they took her pictures, man, like big whoop. What say you, my friends? What say you?
Naked. And the way you know that is the other nurse came in and testified. Do we recall? Alcia AC, I've got her name here. The other nurse that's seen in the picture. And she said, yes, Maya was stripped. Maya was naked. Yes, we did hold her down. And Beatty, and we also know because you saw the deposition testimony of Kathy Beatty, in which he said, unfortunately, we did. That's not something you say if you're particularly proud of what went on. Which begs the issue, then, if Ms. Beatty is willing, if you believed the other nurse, who frankly did not seem capable to me of misrepresenting anything, if you believed the other nurse that in fact Maya was stripped down, and if you believe that she was confirming what Maya testified to, and they never caught Maya in a single inconsistency in her depositions, did they? Not once. If you believe those two, that means that Kathy Beatty was willing to get in here in front of you and completely and utterly misrepresent a key fact in the case. how reliable is that testimony as to anything she has to say? Or was this the type of person getting caught who's willing to say almost anything to get themselves out of it, or what they perceive out of it? And for Jack, again, I apologize to him for him ever having to hear Detective Graham's voice again. Lord knows that's traumatizing enough for him. Detective Graham's techniques in attempting to flip Jack by telling him, among other things, that I'll put you away for 20 years if I think you're harming that child, and trying to get him to say things against his own wife were completely and utterly despicable. Jack was faced with a circumstance where, if he didn't cooperate with this lady, he truly feared, A, he could go to jail, B, that they were going to work some way to make sure Maya never got out of there. And even then, he did his best to protect his wife. But you know what? It did have an effect. It did have an effect because it drove a wedge between Beata and Jack. It caused Jack to question the actions of his wife. And by the end, when you read those suicide notes, you'll see, for instance, that Beata actually gave the rights to her parental rights to her sister. By the end, and this gets into what happened with Beata, even her marriage to her appeared to be brittle and with problems.
Please stop spreading misinformation in the chat. It has to be unanimous. The judge said it has to be unanimous. Today, we watched that part, didn't we? It has to be unanimous. Please stop spreading misinformation, everyone. Florida law, 6 out of 6 must agree, unless the parties agree otherwise. They did not agree otherwise in this case. Are we settled on that? Okay. Oops, I didn't mean to do that.
Child is away from her. She believes her child to be in desperate trouble. She believes that her child could end up as another CRPS fatality. She believes that her husband, while loving her, there's a rift. She feels isolated. She feels alone. And she is motivated internally by about the strongest urge, the maternal instinct, that we know, and even in all mammals, let alone human beings. When you're looking to see whether you should check yes, that it was what Johns Hopkins did, whether they were a substantial factor or that she acted on an impulse, please consider how powerful the maternal instinct is.
You have 15 minutes.
There's 4 women on the jury. 4 women on the jury, so I'm sure the maternal instinct is alive and well. Yeah, Sassy, I saw more than one, Sassy, but the mods are good. I'm pretty sure they're gone, but if they're not, let me know.
I don't think these folks here get it. I still don't think they get it.
They don't get it. You're right, they don't get it. Oh, those papers, I can't.
Okay. Let's play then 2695. This was a mom who loved her daughter. What I found interesting also while we're looking at it is that the defense took.
Hold on a second. Is your video monitors on? Okay, Mr. Reyes, I'm going to turn it off and turn it back on, see if that cycles it. Is it there now?
That's it now.
Try this. Did it come on now?
Can you hear me now?
Well,
Is it there now? Mr. Reyes, I'll try that. And Mr. Anderson, I'll give you a couple extra minutes.
thank you, Your Honor. just a note while we're waiting here, check out Exhibit 3115, which was that recording with Beatty jumping in, and then compare it to their recording about can't talk, or the recording about can't talk about the case. It was Kathy Beatty. No, if we can play 2695, is that like they're not going to be able to do it?
We'll do it.
What I'm trying to show here is that it's two things. First, the relationship here between mother and daughter, and a little bit about what each of them lost.
That's I love you.
Can you see it? Nice.
Now go down
Not a big
slowly.
one.
Go down slowly. Good job. Good job. Very good. Excellent.
Is she supposed to still be faking there? I'm losing my timeline on whether or not they think Maya had CRPS or not. Playing piano for my mom. I don't think I'm going to try to go through every single tidbit that they pull out. I go back to, again, when I woke up at 1:30, which is I've been in the same courtroom with all y'all. So we all heard the evidence, and you all wrote a novel for about every witness. So I have great confidence that you will put everything they said into the perspective of things. One thing that really upset me was this idea that when she was in room 709, she could either escape or it wasn't that big of a deal. Somehow I believe that having to defecate on yourself is a pretty big deal. And if she couldn't get a nurse in to even help her over to the commode, it is really difficult to believe how Maya would be able to escape that room. I think that what we're dealing with here are a number of attempts to just pick at the edges of what was going on. I don't think they've rebutted anything that we've said. They've come in and tried to show you inconsistencies. But here's the thing about human beings and trying to recreate history this long ago back. This family's been seeking justice for 5 years now, 7 years since this happened. Pretty brave family. And you're never going to have everybody agree on everything. Moreover, if you did, such as what I think happened with a lot of the defense's witness, they sounded remarkably the same in a lot of things they were saying. I don't think that's a good thing. I think that as jurors, you're able to tell when another human being is being candid with you, frank with you, and really trying to tell you what's going on, or when they're telling you something they are trying to get you to believe and talk you into something. I brought in as many live witnesses as I could because I believed each one of you would prefer to have the human being here in front of you so that you could judge for yourself all of their different reactions to things, so that you would be able to know when somebody was just not comfortable or not. And the nurses at the end, yeah, some of them were nice, but some of them just seemed like they were trying a little too hard. The shotguns thing drove me freaking nuts. And so I just don't think it was effective to have people come in with sort of a canned speech about this, because I kept saying to myself, if you cared so much for this child, where were you? She had to be trying to express some things. What Maya said, it's pretty smart for a 10, 11-year-old. She thought, maybe if I'm super nice, they'll let me out of here. That's why she was going through all these things. We're talking about a child who's trying to survive in a very bad place. She's trying.
I'm sorry, get the video monitors on my phone. No, they're
No.
I apologize.
It's okay, Judge.
I took that.
And in the end there, I thought with putting up the photographs of Maya just trying to go out for an hour at her homecoming, I don't know what they're trying to say there. Is that evidence you somehow find? Maya waits to the end of the day before picking a dress, not knowing if she could even go because of where her pain was in. And she didn't have her mom for this important rite of passage. No mom, daughter prom shopping, no pre-prom makeup, no nail sessions with mom, no mom for the excitement of pre-prom photographs. And after it's all over, she comes in here and sees that they found on somebody else's, a friend's social media, a picture of her. I don't understand the relevance of that. Did they not hear through all of this that this disease is such that you can have a wonderful day and then have 4 bad days and then 2 weeks, maybe a month of great relief, only a 2 or 3, and then end up with 4 days in your room in a fetal position? Did nobody pick up on that over there? I'm hoping that you will see. Yes. I know you're ready to get back there and do your job. I know you are. I try to wrap up. It's a tough time for a jury because they're like, I'm going to get back there. Okay, you told me all this stuff. I'm ready. But please, when you go back there, think about how life really works. Think about what it took for them to get here. Think about how important these ideas that they were fighting for are. When you're considering damages, think about this. She looks a heck of a lot like her mom. And I think every time she looks in the mirror the rest of her life, she's going to get reminded of all of this. That's a long time to continue to live through something like this again and again. Thank you.
Okay, and that's that. Let's go to the chat for a bit, huh? What do you think? Effective, not effective? What worked for you? What didn't? There's a bunch of questions up here that are starred, so let me get to those. Hi, Melanie. Thank you so much for the super chat. Are expert witness summaries not allowed into evidence and possibly why jury cannot find the information they want from Money Lady? Yes, they are not evidence. They can testify. Their testimony is evidence, but their reports are not. So that report was not given to the jury. Apparently, Anderson tried to get it into evidence. The defense objected and the judge did not let it in. So tomorrow they are going to read back her testimony. I have it queued up. If you guys want to watch it now, let me know. I have it ready to go. Hi, AJ. Thank you for your super chat. No cupcakes allowed. Team Maya. Yes, I also have Team Maya merch. It's 20% off actually today. If you guys want Team Maya shirts, 100% of all the proceeds that, all of my profits are going to CRPS research. So it's a good way to support. And the t-shirts are really cute. HB, do you think they are going through verdict money on each question, or have they done the verdict points and are going back over them for damages? That's a good point. I think they probably just got to the first question and stopped, or they went through and found they may have done liability on all questions and then they were going back to figure out the money. You're right. They could have done it that way. They have the option of doing it whatever way that they choose. And that's a great point. Hi, Magical Mary. Thank you for your email and for your super chat. Yeah, Carroll v. Carroll. That's the Florida case where Judge Carroll was in front of that appellate attorney, right? You said he worked for him too or something. Dave the Pious, hated or dated? Thanks for your super chat. Going back to the yearbook pictures. Yeah. All the girls we hated in high school, all the people we hated in high school. Magical Mary, thank you again. Does the jury know that after they do this, they still have to go back to determine punitive damages? I don't know, because if you guys have watched more of it than I have, and you went through every single jury instruction, I didn't see it on the verdict sheet. So I don't know if they know that part. I know a lot of them have to leave. They have jobs, they have families, they've been there for 9 weeks. Hi, Jay Smith. Did the jazz hands have to do with the court proceedings or something else? Yes. Yesterday, when the judge was dismissing juror number 1, and it looked like for a second Greg Anderson agreed to it and they were going to stipulate, the woman sitting at the defense table went, and they were all happy. And we think that that's when Jack said, come here. I don't want to agree. I don't want to agree to let him off the jury. So that's what I had to do with. Hi, Sarah. I'm really surprised at the fact that Jay Hatch billed the Kowalskis for CRPS in closing arguments. I thought the point was important and should have been included in closing. I thought he did include that somewhere. No? I'm not sure. I'm not sure who you're referring to. Which attorney? Solo Yolo, thanks for your super chat. Cheers to the K family. They could have settled for good money. They want people to know, to be aware, to shine light on what J Hatch fought to hide. I think you're right. I think you're right. And for what everybody goes through who suffers from CRPS or any other chronic pain disease and are gaslit by medical providers and hospitals that want to second guess your right to treat your child. Hi, Sarah. Thank you for your super chat. Melanie, thank you. You're an everyday angel too. My brother has spent years gaslighting my pain with CRPS. This case is happening in the city he lives in. Wow. I'm so sorry to hear that. I don't think your brother's watching, but we could have a chat with him if you like. Desert Quilt, thanks for the super chat. Maddening in 2023 that J Hatch implied CRPS isn't a big deal or really a thing. I was diagnosed in the 70s and even then received proper treatment in numerous facilities. Ignorance can be criminal. Wow, you must live in a great place with a lot of medical knowledge, because even back in the 70s, it was RSD at the time, and it was very difficult to diagnose. And I don't know how long it took for you to get diagnosed, but everyone in the chat here or people that I know that have it say it takes a long time to get to that diagnosis. Hi, Ravonda. Thank you so much for the super chat. Notice the purple tie. I don't know if you talked about this or not, but someone mentioned on an earlier AR group he's wearing purple knowing Maya hates this color. Yeah. Well, we know that Maya hates that color because she testified that Kathy Beatty always wore dark purple and she could never wear the color and she hates the color. Yeah, if that's intentional, that's really kind of sleazy. Raka Fraka, thank you for your super chat. I can't get past that only 5 days after Beata took her life, J Hatch discharged Maya. Why? Was there a miracle in those 5 days? No, the hospital considered Maya no longer at risk of abuse from Beata. Yep. And we did this the other night on my stream. I forget which night it was. I don't know. I don't think it was last night, maybe the night before. And we read that judge's order when he released her. The jury's not going to see that, but we went through it and we read the entire thing. And you're right. It's horrifying. It's horrifying. And it's heartbreaking to read. And it's upsetting that the jury isn't going to get to see it, but more prejudicial than probative. And chapter 39 and all that. Hi, Jermaine. Thanks for your super chat. Shapiro's the type to tell a girl, yeah, our victim, that it was only 10 minutes. Yeah, disgusting. Oh, thank you, Shiraz, for becoming a YouTube member. I think you're going to like it here. We have a lot of fun. We have a lot of fun on this channel. This is a tough topic. We talk about all of the tough topics, and we're not afraid to. And it's a kind place to talk about these things. So, yeah. Hi, Swifty Sue. I thought it interesting to hear other families that had the same fate. Yeah, John Stewart spent 300 days in jail, and he did confront Sally Smith outside of the courthouse. And it was because of her allegations that he spent 300 days in jail, because he couldn't afford a lawyer to represent him in the dependency court proceedings, which is another thing we've been talking about a lot, that if you don't have money, it's almost impossible to defend yourself against these allegations in a dependency court. He spent 300 days in jail. He confronted her outside the courthouse. That's why when she came in to testify live, she seemed like really rattled. That's what happened, because she was confronted right before she came in. Yeah, it's crazy. Drop the merch link in the chat. Well, I can. I don't know how to do that, Scott. I don't know how to do that. Didn't I tag some of it in the stream? I'll tag some of it in the stream. Thanks for standing in the gap, Melanie. I think you was like, thank you. Thank you so much. The judge was, I want to say Judge Hayworth, Haworth, but we read it the other night. We went through it, and it's heartbreaking. Yeah, you should go back and watch that. Not right now. Do you guys want to watch The Economist? I can speed her up. Her testimony is about an hour, but if we speed it on double speed, we can watch it in a half an hour. It's up to you guys. What do you want to do? What do you want to do? I don't know. Well, I'm not seeing anything. You guys feel tired enough from today, from watching all this stuff, or do you want to watch it? Do lawyers with cases normally become this hateful of opposing clients? No. No, it's weird. It's like he's taking it personally. And you know something else that I noticed when was it last night that we watched the media interviews of Shapiro? He says we a lot in those interviews. We think this and we think that and we did this and we did that. He doesn't say my client ever. He says we, and it's odd. It's really odd. Yeah, it's crazy. Thank you, green-eyed Southern girl, for your super sticker. I appreciate you so much. All right, The Economist. All right, whoever wants to stick around, let's watch The Economist. Let's watch Kirby. Let's watch Kirby. Yay, Kirby. And then while I turn it on, I'll find the merch, and then I'll drop the link in the chat, like Scott said to do. All right, because I listened to Scott. All right, let's see. Where is this? This was day 15. Wow, this is hard to believe. Okay, so she testified all the way back on October 13th. No wonder nobody remembers what she said. Let's bring it up.
There we go.
She testified by Zoom.
Okay, Ms. Kirby, since I was in at the border of the state, so
Okay.
you were actually seated in Georgia right this second, but you're testifying. The echoes because of Mr. Reyes' computer.
Reyes is the tech guy who I said has been doing all the work this trial.
We fixed it. There we go. Okay, so Ms. Kirby, because you're in Georgia, I need one of two things to happen. Either you need somebody there to swear you in, or I need you to agree I can swear you in. Now, by agreeing to me having you swear you in, that means that if there was ever any type of action for like perjury or to enforce against you, you are consenting to jurisdiction here in Sarasota County, Florida, because you are actually testifying in a courtroom in Sarasota County, Florida. So with that understanding, do you agree I can swear you in?
Yes, Your Honor, I agree.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you give is the truth?
Yes, I do.
Thank you. You can go ahead and lower your hand. And Mr. Anderson, you may inquire.
Thank you, Your Honor. May I inquire as to whether Mr. Whitney, if there are numbers here, can write them on the whiteboard at the same time? We can move it over, but I just want to
Your whiteboard, sure.
Okay.
I don't think we can move that other whiteboard without a lot of changing of locations of wires. Where Mr. Anderson previously set it up is fine with me if it's okay with the court reporter.
Please state your name for the record.
Yes, it's Christy, Kristi, Kirby, Kirby.
And Ms. Kirby, have you been asked here as an economist to evaluate the economic damages of the Kowalski?
Yes, I have.
I'd like you to give the jury the benefit of some of your background, training, and experience, starting with the name of your firm, but then going into your degree beginning in undergrad.
Sure. I'm self-employed, and the name of my firm is Mulder and Kirby Economist. For my undergraduate degree, I studied education. I also have 2 master's degrees. My first master's degree is also in education, and both of those are from Ohio University. And then my second master's degree is a master's in business administration, and that's from the University of South Florida.
So that's an MBA.
Yes.
Okay. All right. Explain to the
Hold on one second. Members of the defense, if one or more of you want to relocate over to where Mr. Whitney is, so you'll be able to see when he writes, I'm fine with that. And
all right. Can you explain to the jury what an economist is?
Yes, an economist is someone who studies the labor and financial markets in our society. So in a case like the one we're here about today, an economist would be looking at inflation, interest rates, growth in medical costs, and growth in wages over time, and then how those variables correlate and interact.
Okay. And so in addition to your MBA and your other degrees, can you tell us about any additional education or experience you've had towards offering opinions here today in the field of economics?
Yes, in addition to my educational background and studies, I've been working as an economist on a full-time basis for the past 7.5 years. I've worked on hundreds or likely thousands of cases by this point and spent countless hours on the research that I'm here testifying to today. I worked on cases such as employment cases, defamation cases, commercial damages cases, death cases, and personal injury cases like this one. I've also taught coursework at the University of South Florida, and I've done work for the United States Department of Justice.
Right. And
So then you're getting paid to be here, or actually to be there, being here.
Yes, I get paid for the work that I do. My initial retainer is $1,800. I then charge $250 an hour for any analysis, research, calculations, waiting time, and travel. And I charge $900 for up to 2 hours of testimony by deposition or at trial.
That's not a lot. That's not a lot as far as expert witnesses go. She's a bargain, quite frankly.
Then we'll keep it under 2 hours. In your experience in private consulting, have you evaluated cases where you've been asked to evaluate the loss of support and replacement of household services for surviving family members, like we have here, and then reducing those to present value?
Yes, much of the consulting work that I do relates to these types of issues where I'm studying growth in wages historically, personal consumption expenses, fringe benefits, taxes, the replacement value of services, increases in medical costs over time, and then interest earnings. I'm looking at how these variables correlate and interact over time.
Okay. And do you do
Hi, Sylvie. Why can't the judge just show this clip to the jury? Because they didn't record it. They didn't record the Zoom. And they can't use anybody else's feed, I guess. So they're just going to have the court reporter transcribe this overnight and then read it to the jury, which I think is far less effective than just having them watch her testimony again. But that's just me.
work for both sides of the spectrum on cases where there's a plaintiff and cases where there's a defendant for the defendant?
Yes, and the methodology that I use to reduce damages to present value is the same regardless if I'm retained by the plaintiff or the defendant.
Can you explain to the jury a little bit about present value? They'll hear it, probably see it in the jury instructions, but can you explain a little bit about why it is and how you come about it?
Sure. So present value is the amount of money that someone would need today to cover costs or expenses as they occur into the future. So we're here regarding the Kowalski family. And when I'm talking about present value, I'm going to be talking about the losses that they've experienced and how much money they would need today to cover these expenses or these losses as they occur into the future. And I have to take into account several variables for that. One, I have to take into account the increases in medical costs that will occur over the future time period. And I also have to take into account the growth in wages. Additionally, while I'm looking at the growth in those two variables, I also have to take into account that any money they receive today can be invested and earn interest on safe government investments. So by the end of the time period and the damages I'm calculating, the present value amounts that I give, the Kowalski family would be no better off or no worse off financially. They're just replacing the economic losses as they occur into the future.
I see. So the amount of money invested now that would pay out a sufficient amount of money to cover these expenses in the future. Is that right?
Yes.
And this would go out towards their lifetime or their work lifetime.
Yes, that's correct.
How do you determine the lifespan here, both work and human lifespan?
Regarding, so in terms of life expectancy, I rely on government data. It's collected and analyzed by the CDC and published by the National Vital Statistics reports. So that's what I've relied upon for calculating life expectancy in this case. And then for the work life expectancy of Maya Kowalski, I relied on the vocational assessment of Mr. Tremp. He's calculated a work life expectancy to age 65 and age 70, two scenarios. Mm-hmm. And then for Beata Kowalski, I've calculated her damages to her age 58.1 years old, which is 7.5 years into the future from the start of this trial docket in September.
All right. And so, and let the record reflect that your life expectancy tables are in evidence, but can you tell the jury which particular tables you use in this case, in case they want to double check?
Sure, no problem. So regarding the calculations I've done for Maya Kowalski, I have used the 2020 life expectancy tables for white females. This is the most recently published data. It was
okay. So it sounds like the life expectancy tables are in evidence, but her actual calculations are not.
Published in August of 2022. So even though it says 2020, it's the most recent data that we have available. It takes some time for the government to collect and analyze and publish the data. And then, okay. And then for Beata, I use the life expectancy tables from 2017 for white females. I calculated her life expectancy at the time of her death and then deducted for the past time period to get her life expectancy. And then also related to the economic damages that I've calculated regarding Beata, I've calculated Jack Kowalski's life expectancy using the 2020 all males white males life expectancy tables.
Are we going to get to those later, or should you give them to us now as to what the life expectancies are?
I'm fine either way. We'll probably discuss them later as well, but
Fine with me. All right. And have you been previously qualified as an expert in the field of economics in a court of law?
yes, many times.
All right. Tell the jury what information you were provided in order for you to do your calculations and provide them with some present values of economic damages.
Sure. Would you like me to go over what I specifically reviewed for Maya and then Beata, or would you like me to give them all of the materials I've reviewed at once?
You can separate them out if you want.
Okay, sure. So for Maya, some of them will overlap, but regarding Maya, I've reviewed a copy of the fourth amended complaint, plaintiff's answers to interrogatories, which is sworn testimony by the plaintiff for questions posed by the defense. I've also reviewed the life care plan of Dr. Bifuco, the vocational assessments of Mr. Robert Tremp. I've reviewed the Aetna summary and medical liens regarding past medical expenses, and then the deposition transcript of Maya from March 12th, 2022, and the deposition transcript of Jack from November 6th, 2019. For Beata, I also reviewed a background questionnaire and a household services questionnaire that was completed. I've reviewed tax documents, which includes W-2s and other earnings documentation from 2013 to 2018. And that's the additional information I reviewed regarding Beata's calculations.
Yes, ma'am. And what research do you do in order to reach your conclusion on the economic damages? And once you have the basic facts?
Sure. So for research, I've researched life expectancy, as we've discussed, the growth in medical costs and interest earnings on safe government investments, and the growth in wages. Those are things that I review routinely in my practice for the cases that I'm working on. And then additionally, the research that I did regarding the economic damages for Beata, I've looked at household services wages, specifically growth in wages for nurses, personal consumption. I've looked at fringe benefit information from the Kaiser Family Foundation. I've also studied and reviewed the American Time Use Survey and done calculations and review of taxes.
So the jury knows, what is personal consumption and how does it relate to wrongful death damages?
Sure. Personal consumption are expenses of the decedent that would no longer occur after their death. So it includes items such as food, clothing, a portion of the utilities, recreation or leisure expenses, those types of items.
Good. Have you worked with Dr. Bifoco and Mr. Tramp in the past?
Yes, I see their reports frequently in the line of work that I do.
And they'll be in evidence in a moment. Or yes, sorry. All right. So now you've defined what you have, what research you did. Can you tell the jury what, well, first let's do the past medical expenses and let the record reflect that the Aetna bills are in evidence. I'm not sure which number, but they're here. And I ask you to perform some computations as to that.
Yes.
And can you please tell the jury, based upon your background, training, experience, and to a reasonable economic certainty, what the past medical expenses insofar as the Aetna insurance came to?
Sure. I've received a summary of the past medical expenses and I totaled them up to be $561,298.55.
Right.
That's exactly the numbers that they're looking for. Hopefully they are going to take notes when they read the testimony back, and then it shouldn't be too long.
All right.
Your Honor, very briefly approach on that issue.
Okay. And Ms. Kirby, I'm going to mute you so that you're not going to be able to hear what we're talking about.
Okay, no problem.
So Kate says, I wonder why the judge approved the defense not wanting this in evidence. Weird to me. The deposition, she testified in court via Zoom. It was her written report that they did not allow into evidence. And it's a proper objection. It's not evidence, it's her opinions. So I can see why they would object to her report being in evidence. But the testimony is evidence. So that is why they're going to read it back tomorrow.
I believe I indicated in the items I reviewed, I also reviewed some liens, but the number I provided was only the Aetna billing.
Got it. All right. And were there additional claimed amounts and let's just go.
I just want to rewind that because we were talking about liens the other night, and I want to see what you have to say about that.
Of past medical expense.
Ms. Kirby? Yeah. Oops, wait. You may continue, Mr. Rand. Oops, wait. Can you hear us again, Ms. Kirby?
Yes.
There you go.
Yes.
Ms. Kirby, the reason for all that was I think either I misspoke or you did, because I asked you for the amount of past medical expenses billed, and I think you said lien, but it's the same, but it's the number's correct.
I believe I indicated in the items I reviewed, I also reviewed some liens, but the number I provided was only the Aetna billing.
Got it. All right. And were there additional claimed amounts and let's just go down there. Was there an additional amount for $375?
Yes.
$314,285.79.
Yes.
$9,334.47.
Yes.
Have you had the opportunity to total all of those into the 561,298.55, or is that something we need to do?
I haven't totaled that, but I can. I brought my calculators today.
Okay. Let's have at it.
If you give me just a moment, thank you.
Okay. Sure. 375. Right. 314,200.
Hey, Caroline. Caroline says this was not allowed because it was considered hearsay. Can you explain, please? I don't know what you mean. This is her testimony in court. She was testifying by Zoom. So I'm not sure what you're saying was not allowed in. Her report is not allowed in, but her testimony is allowed in. Hope that clarifies it.
$85.79. $9,334.47.
I'm just double checking it. Just a moment. Okay, are you ready?
I am ready.
Okay, it's $885,293.81.
All right. And I have to ask you, do you have an opinion based upon your background, training, experience, and to a reasonable economic certainty as to whether this number, $885,293.81, represents the documented medical bills paid in this case?
I can say within a reasonable degree of economic certainty that the addition that I just did regarding the numbers that were outlined are provided. But that's the best I can get there.
Okay. And then let the record reflect that the Aetna bills are at Exhibit 2017. All right. Now, you used a term before called earning capacity. What do you mean by that?
Yes, a person's earning capacity is their ability or their capacity to demand wages in the open labor market. It's based on their education, talent, training, skills, and experience.
Where do you get that information? Or do you rely on Dr. Bifulco or Mr. Tremp for that?
Well, for the definition of earning capacity, that's general knowledge in the field that I work in and in a vocational assessment, but I've relied on Mr. Trump regarding the figures that I've used for earning capacity.
Right. All right. So now on that, can you explain how you did your calculations regarding the present value of Maya's future loss of earning capacity?
Yes. I've relied on the vocational assessment of Mr. Trump. In his vocational assessment, he indicated that Maya's pre-injury earning capacity was $1,883 per week, which is an annual amount of $97,916 per year. He began these calculations when she turns age 28. It's my understanding to allow for time for her to complete collegiate level coursework. And then he's calculated her work life to age 65 and 70. So with that information, I can calculate the present value amounts of there. Okay. And then he's provided two scenarios. One, which is a total loss of earning capacity, and the second, which represents a 50% reduction in earning capacity.
Okay. And these are just based on numbers provided, not any specific data to you.
I've relied on the vocational assessment of Mr. Trump. In his report, he outlines the data that he relied upon, but I'll allow him to test. Yeah, that sounds good.
I'll ask him. All right.
Okay.
Tell us the numbers then for the four scenarios that were calculated for Maya's future loss of earning capacity. And if you would, can you tell us, before you say them though, are these calculated with a reasonable degree of economic certainty?
Yes, they are.
So these are the present values. And if you would tell us what those are.
Sure. So the first two items that I'll give will be the present value to age 65 for first the total loss and then the 50% reduction. And then I'll go on and give the present value numbers to Maya's age 70 and at the total loss and then the 50% reduction.
Okay.
So the first number, and I provide my present value numbers in the form of a range.
Okay.
On the low end of the range to age 65, the total loss would be $3,015,765 to the high end of $4,358,011.
And sure. I think she said, well, go ahead. Could you repeat them, please, for Mr. Whitney? 3 million.
Thanks, Margie.
$3,015,765
Right.
to $4,358,011.
And what accounts for the range here as opposed to a specific number?
Those are based on the assumptions I make when calculating present value between growth in wages and interest earnings on safe government investments.
Understood. All right. And so then with a 50% reduction to age 65.
Sure. The 50% reduction on the low end is $1,507,883 to the high end of $2,179,006.
So these are the amounts of money, if invested now, would pay out sufficiently to make up for lost future wages or diminished earning capacity. All right. So let's talk about age 70.
Sure. Age 70 for a total loss on the low end is $3,344,625 to the high end of $5,079,783.
Okay. And that's for the total loss. And then for a 50% reduction.
Sure. On the low end is $1,672,313 to the high end of $2,539,892.
Now, either from your own experience or from your research, has it come to your attention whether statistically more people are working past 65 and into 70 than, say, 30 years ago?
I would say people tend to work longer now, but the minimum Social Security retirement age is 67. But if you wait a few more years, you can technically collect more if you retire at age 70.
I see. And was that one of the bases for your calculation, the assumption that folks would retire at those ages?
No, I just relied on Mr. Trump for those two ages. Those are the ages he outlined.
Okay. All right. Are there other ways to calculate present value other than the ones that you've explained?
Yes. So the methodology I use, I discussed, I'm looking at the relationship between growth in wages and interest earnings on safe government investments. And when I look at the data historically over time and smooth it out, it falls within a net negative 1% to a net positive 1% relationship between those variables. On the low end, what I've given, and I'm just giving this to give some context to these other methods so you can see how it all fits in.
Right.
But on the low end, the net negative 1% reflects a situation where, for example, your growth in wages or medical costs are being outpaced by interest earnings on safe government investments. So you're earning slightly more interest, an average of 1% more than the growth in these other variables over time. And that's why you need less money. The opposite end, the plus 1%, reflects a situation where your growth in medical costs and wages are outpacing the interest earnings by an average of 1% per year. And that's why you need more money, because your interest earnings aren't quite keeping up with the growth in those costs over time. And that shows my range.
And
Go
ahead. No.
Okay. Another methodology that you asked, one is called the forecasting method that some economists use.
Mhm.
And that's where they choose a growth rate to grow these expenses into the future. And then they choose a discount rate where they discount it back to what's called present value. So they grow it to future value and then discount it back to present value. My calculation takes into account both of those variables at the same time. But when you use the forecasting method, you just arrive at one number for the present value amounts. And then the offset method, this is the easiest method out of the three. It's called the total offset method. And that assumes that any growth in wages or medical costs is completely offset by the interest earnings. So you end up with a 0% relationship. So in that scenario, you would just take the annual amount and multiply it by the number of years over which you'd like to calculate the damages, or which the damages are calculated. And that'll give you a good approximation of present value. And it gets you pretty much right in the middle of my range of the net -1% to net +1%.
Now, are all of these
I don't know about you, but this is when my eyes start to glaze over. When I start hearing all this stuff, it just makes my head want to explode. Like, no wonder they don't remember any of this, because I'm just like, oh my God, what? What is she talking about? I mean, I know I have it on a little bit of a high speed, but it's like, you get these numbers and then you get these numbers and you have to like factor them back into present day value, right? Because you're not giving them the present day value, and that's less money, worth less money now than it would be if you waited over time, and then if you invested it, and then there's a lot to this, and I can see why they would like to have a chart. I would like to have a chart. It's a lot. It's a lot, but the pain and suffering award is what, or awards is what Whitney was talking about when he was saying, okay, I want you to use an hourly rate, and then I want you to factor it out for how many hours they're going to have to live without their mom into the future, until like what their life expectancy is, because pain and suffering is a less tangible number. They can come up with any number they want. So he was giving them a guide by saying, $100 an hour, I think, is fair. And then her numbers are more tangible. She's saying, okay, here's how much money Maya would have earned all the way until the age of retirement, or until age 70, because people are working longer. But if you take that entire lump sum of money and you factor it back into present day value, here's a tangible number that you can award for loss of income, future medical expenses. Past medical expenses are tangible because they know what the past medical bills are. So her numbers, as an economist, that's what they're paid to do, is to do all of these numbers and factor them into the future, and then you discount them back into present day. It's a whole factoring sort of calculation. If anybody in here is a math person, an analyst, does that mean you understand any of this stuff? I don't know. It's a lot. It's a lot.
methodologies, have they been, in your experience, accepted by courts at different times for different reasons?
Yes.
And so if the jury, on the offset method, then would it be correct to say that if the jury, for instance, determined that Maya's earning capacity and hence loss would be greater, if they chose the offset method, it would just be the number, whatever it is? In other words, there's zero need to reduce or increase?
Right. If they felt that any of the calculations I provide today need to be adjusted based on the testimony they hear, they would just take the annual amount that they feel is appropriate and multiply it over the number of years that they feel is appropriate. And that'll get a good approximation of present value. It's actually, my understanding, mandated in the state of Pennsylvania to calculate present value using the total offset method.
Okay. In the state
But
of
we're in
Pennsylvania.
Florida. Yeah, we're in Florida. So you don't have to do it here. And most economists will use either the methodology I use or the forecasting method, but the offset method is also very much acceptable.
All right. And do any of these damages?
Okay, so I think you get the basic idea. If you want to go back and watch this entire testimony, it is day 15. And Law and Crime has great chapters. So you can go back and watch the entire thing if you want, but you can see how complicated this is and why the jury wants to hear this again. But also you can see that they are agreeing with her numbers. They want to hear her numbers. So that is a good sign. So I think they just want some sort of guidance on how to arrive at those numbers. And that's a good sign. So to me, they've already decided liability. They just want to know how much do we write the check for? It's not a matter of, do we write a check? It's a matter of how much. So yeah, thank you, Shiraz. Couldn't believe they were talking about awards so soon. Not sure what it means, but maybe a good sign. Yeah. So we decided that either they went through the entire verdict sheet and filled out liability on each question and then just went back to figure out the damages, or they may have gotten stuck on question number 1, where it asked for future medical expenses. And that's when they came in with their note. But based on the fact that they were out for a couple of hours, right? What time did they start deliberating? Somebody tell me, 3-ish. They came back at 6:15, I think. Caroline, I'd rather poke myself in the eye with a sharp stick. I know it's complicated. If that's what you're talking about, numbers. I don't know. Maybe you guys are having a private conversation in there somewhere. What'd you say about the juror question? Oh, that's right. Somebody sent me a juror question. Okay. Yeah, you sent me a great juror question. All right. You know what? Let me see if I can find that again. Since I just closed it, I should be able to find it, right? You would think. I mean, I always have 700 tabs open on my computer. There's no reason why I shouldn't be able to come up with it right away. Talk amongst yourselves for a minute. Should be right in my history, right? Yeah. Gotta get rid of that chat. That chat is evil. All right, here we go. See, I do read your emails. I don't always respond to them because I'm inundated with email. Email is the bane of my
Time
existence.
discussion of the medical bills. The answer is yes, those are in evidence, and you'll have those.
But I get them.
Hold
Hold on.
on. Ms. Kirby, can you hear us now?
Yes, I can.
Great, thank you. And members of the jury, there was a note I received during the questioning. Will we get a copy of that? And it was at the time of the discussion of the medical bills. The answer is yes, those are in evidence, and you'll have those.
The medical bills are in
Both of you
evidence.
back in the jury deliberation room. Next, or the first question for you, Ms. Kirby. You have covered multiple calculations and the theories used to arrive at final figures. All this is well and fine using Maya in this example and treating Maya like a quote stock end quote traded on the stock exchange. Her past educational performance shows the ability for more than favorable to high returns. Did your calculations take into account that Maya could, like some witness in this very courtroom, Maya had the capabilities to make exuberant amounts of income over the course of her lifetime? Or were middle of the road statistical income levels used in your calculations?
Exuberant. I think they meant exorbitant. I'm not sure if you read it wrong or if they said it wrong.
Sure, good question. So I've relied on the vocational assessment of Mr. Trump for her pre-injury earning capacity. And based on my review of his report, he will defer, or he will explain that later, how he has allocated the 97,000. Let me find it. Sorry, got too many reports here. Okay, the $97,916. I did do research on the same data that he provided because the data he provided was from 2019, and the current data, same data, is now would equal $108,316 or $316 per year, so 108,316. I haven't included that higher value. I've just relied on the figures that are provided in Trump's report, as he indicated when he gave an updated assessment in August of this year that he didn't change any of the opinions in his report. And part of that question also referred to the stock market. And so I'm not sure if they're inquiring about the interest earnings on safe government investments, but that data is standard data that economists use. It's the most risk-free investment, as this money is not supposed to be placed at risk. When you invest in other avenues, you may yield a higher return, but you also have a greater risk of losing that money, and it's not guaranteed. So the economists in my field routinely will rely upon the interest earnings on safe government investments. I haven't made any adjustments to the vocational assessment that Mr. Trump has provided and the figures that he outlined.
Next question, Ms. Kirby. I may have missed it while scribbling my other question. Was the possibility that Maya's PTSD affects her ability for possible relationship, then marriage, family, children, and all the quote things, end quote, that her past family enjoyed, but now will never be able to continue? She now may not be able to enjoy, quote, motherhood, end quote, like her mother did. And if Maya does have children, was there any, quote, monetary value, end quote, placed on the added stress Maya would have when her children went to a hospital for something? Or should I add, if able to, additional quote monetary value, end quote, to your figures?
You have a good jury with good questions, but I have,
Right, because that's not really a question for an economist. That's something that they get to choose the dollar amount for.
I have not added any, those are what I believe are considered pain and suffering, loss of enjoyment of life, or human damages, as Mr. Anderson referred to them. I have not calculated any value for those. I've strictly calculated the economic damages.
Right, so they're already thinking about that. They're thinking about, give us some guidance on how we figure out what that number is. Because if these other numbers that you're giving us are so high in the millions, well, then her having PTSD and being afraid to have children and not having her mother when she gets married, that must be worth 10 times more. That's what it says to me.
In this case, so the hard dollar amounts.
Okay. During the asking of these, I received another juror question. It's one quick question, so I'm just going to see if you have any objection, and if not, I'm going to. Okay, there was no objection.
Okay.
Ms. Kirby, what is the average statistical income of a 28-year-old at this time?
Right now, today?
Well, I didn't bring that data with me, but I think that would be, there is data out there regarding that. I think that would best be a question for Trump to answer, as he's outlined all of the research data and how he's looked at the earnings for that. I was trying to look in his report real quick to see if there was something we could add to that. So the data, and he'll speak to this, but just for a little bit of clarification, it says the data are for persons age 25 or over, and it has the median earnings at $1,883. That's the median average earnings. So in the middle in 2019. Again, I spoke about the current data is a little bit higher than that, but Mr. Trump will be able to speak more thoroughly regarding that information, I believe.
Mr. Anderson, or do you have any further follow-up questions?
That $1,883 is per week, not
Yes, per
annually,
week.
I trust.
No, not annually, and I'm sorry if I misspoke. It's $1,883 per week, or $97,916 per year.
Members of the jury, any further questions? Seeing none.
Okay, don't worry. Somebody said I'm lost. I'm like, yes, so am I. I'm lost too. I'm lost too. Trent was another expert that they called. I think he was the life care planner. And they also called it Dr. Bafulco. So they had a lot of experts on their side, not so many experts on the defense side, which was kind of interesting. Instead of Shapiro just started throwing out numbers like, well, if you find this, then, give them like $1 million each, give them like 5 million each. Very, 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 very strange. Kathy Moran says, question, could JH have offered a contract to Hunter for more than he could make if he gets disbarred? So he disrespected court twice and didn't comply. I don't know. That's an excellent thought. Could they have? I mean, anything's possible, but I don't know that he would risk his license for them. Hey, listen, people are doing all kinds of crazy things every day. That's what we are pretty much reporting on and doing shows on, and you guys are listening to, so nothing surprises me at this point anymore. Do you think the verdict will be overturned specific to the wrongful death? We need to see what the verdict is first. And I am not 100% up on the law in Florida, so if this is a case of first impression, I can't say. Too early to say is what I'm going to say to that. Too early to say. Hi, Maria, but why is her math opinions and aren't opinions from experts fact? No, this is her opinion of what she thinks Maya's future lost income will be based on certain standards and statistics that she has looked at. The jury is the finder of fact. So she can give her opinions and experts testify as to their opinions. Same as Dr. Corcoran. Everything that Dr. Corcoran said is based on his opinion within a reasonable degree of hospital management certainty. And those are his opinions, but they're not fact. Nancy, hi. Where can we find her deposition? Pacer? I don't know. This is her actual testimony. So I don't know if she gave a deposition. She may have just rendered a report and they called her in to testify at trial. Pacer is for federal court. This is state court. This is Sarasota County Court in Sarasota. And I don't know that they filed their depositions with the court. We typically do not do that in New York, but I don't practice in Florida. So I don't know. It may be attached as a court exhibit. I don't know. But again, this is her actual testimony in court on Zoom. Shiraz, I couldn't believe they were talking about awards. So yeah, we talked about that. And Tracy says, thank you for breaking it down. Love my channel. Thank you so much, Tracy. Did you say you're going to cover Sally Smith and the other families she messed up? Dying to see that. Yeah, I have a whole bunch of research on that. It's just that every time I want to go do a show on that, something else comes up. And this has been taking up a lot of interest and time, this trial. So yeah, we will get into Sally Smith. She's left a lot of people in her wake, let's just say. So at this point, I have a cat that is literally like my cat, I think knows how to knock because she bangs on the door when she wants to eat. Like she has an extra thumb and she's 18 pounds and she bangs on the door. I think she just went away because she got mad, but she wants to eat. And we've been at this for 3.5 hours. So I am going to say goodnight to all. Thank you to all of my moderators for sticking in there so long. I know the chat was I think there was a couple of people in there that you had to ask to take a step back. And I thank you for that, for making this a safe place for everyone, to all of my viewers, my subscribers, my channel members. We just started memberships. I'm so excited. I can't wait to do a members only live stream with you guys. And we're going to do that soon. And we're going to keep following this case all the way to the end. So to all my CRPS warriors, I see you. Peace. Everybody, don't forget to like the stream on your way out. You can subscribe. It's free. Hit the bell so you'll know when I go live. And justice for Meyer. Oh, wait, before I go, I want to show you the t-shirts. Hold on, because I did pull up the thing just so you can take a look. Look how cute. Aren't these cute? Look, and there's the hats. And they come in all these different colors. You can get it in pink. And all of these cute little sweatshirts come in different colors. Looks like a dual color one. This cute little football tee comes in all different colors. And then these tank tops. These baseball shirts are cute. A little something for everybody. What do you think? Cute, right? I designed those myself. I'm so proud of myself because I'm so not creative. I'm like the least creative person on the face of the planet. So that's everything. Thank you guys so much. I will see you soon. Remember, be cool, be kind, be classy. Have a great night, everybody. Or a good night's sleep at this point. Good night.